Welcome back to the second day of our roundtable. And in this first session today, we will look at various issues and ways of enhancing customer protection, but with a focus on Part 30, looking at protections of customer funds deposited with an FCM for trading on foreign markets. Housekeeping, we're scheduled to go from 9:30 to noon. We'll take a 15-minute break in the middle of the session, and I think you, for those of you who were here yesterday, you know where the bathrooms are in the back. Again, yesterday was really helpful. We really appreciate the participation of the panelists. Let's quickly go around the table, stating name and company affiliation. My name is Gary Barnett, CFTC.
Tom Smith, CFTC.
Kevin Piccoli, CFTC.
Dan Driscoll, National Futures Association.
Carl Gilmore, Penson.
Stephen Winter, State Street.
Jonathan Short, ICE.
Julie Strike, Country Hedging.
Kevin Foley, Cat and Muchin, Roseman, on behalf of FIA.
Ross Park, Barclays.
Sandy McCarthy, FC Stone.
Gary DeWall, New Edge.
Maureen Burke, Bank of America Merrill Lynch, representing FIA.
Ann Bacon, CME Group.
Bob Wasserman, CFTC.
Great, thank you. Our disclaimer, CFTC staff cannot engage in a discussion concerning matters involving MF Global in light of our Division of Enforcement's ongoing investigation. So we ask the participants to respect our request that such specifics not be injected into the discussion here today. Okay, so let's begin. Very generally, and let's just sort of some discussion some beginning to get us started. U.S. customers who wish to engage in trading in foreign markets can deposit funds with their FCM, who will facilitate the foreign trading by depositing those funds, Part 30 secured funds, with foreign depositories and foreign brokers, which affect the trades, and a variety of issues arise out of the basic arrangement. For instance, in terms of the amount of such funds that the FCM is required to hold in Part 30 secured accounts, Commission regulations currently only require the margin plus method and not the net liquidating method, which is applicable under 4D. Thus, customer funds deposited with the FCM that exceed margin plus could be at risk, resulting in a potential shortfall of funds due to customers that's due to their customers upon an FCM insolvency. Also, if the foreign broker or depository goes insolvent, not the FCM, funds that are on deposit with the foreign broker or depository would be subject to the foreign laws and foreign administration applicable to the foreign broker or depository. And in addition to foreign laws you can't control, foreign laws and regs may provide for a variety of options that could impact the safety of customer funds, including, for instance, as noted in the FIA piece, which I've still not read carefully, but I saw, the ability in at least one jurisdiction to opt out of the foreign law's seg requirements. Other issues arise because only customers located in the U.S. are taken into account for certain calculations and requirements, which has the effect, as my colleague Bob Wasserman colorfully describes it, and I hope we get a chance to describe it later, as allowing real foreign customers who are also involved to feed at the trough without having contributed to the trough, although sometimes he uses the cake or something like that, right? Anyway, another consideration is that these risks, like some of the others we discussed yesterday, are risks that customers are expecting to be backstopped by the FCM, but they aren't taken into account in a nuanced way in the FCM's capital structure or otherwise mitigated. There's a capital requirement equal to 8% of the margin required on foreign futures and options. There's a 5% foreign broker charge. There's a simple requirement that a foreign bank to qualify as a depository must have $1 billion in reg cap. But the coverage of risks that can arise from these issues don't attract a nuanced capital charge or a specific mitigant, and we should be focusing on that, I think, but we want your views on that. Okay, so in that light, just let me ask the panelists, is there any reason not to require FCMs to compute the secured amount requirement under the net liquidating equity method, basically the 4D method, instead of the margin plus method as currently called for under Reg 30.7?
I'll tell you, the committee strongly feels that there's no reason why it shouldn't be done on the net liquidating value method, which is a more conservative method, and, for the protection of all the clients.
Any disagreement? Yeah.
And I believe the SROs would hold the same view.
Okay.
Yeah, Ann Bagan from CME. I think there's absolutely no reason why the 30.7 regs don't mirror the 4D regs as well.
Okay. Okay, thank you. All right, so let me ask you, how can we, and this is, I guess, more open-ended question, but how do we protect FCMs and their customers from foreign insolvency risk? What are some ways, for instance, to just throw a few ideas, should we have a requirement that foreign broker creditworthiness be posted? Should we require double posting, so that for every dollar that's going overseas, there be an equal amount of proprietary funds held back in the U.S.? Should we minimize the amount of funds that are going out, so that the amount of customer funds at risk is minimized to limiting them to what's needed to cover margin on customer positions and some excess or some cushion? What ways can we deal with the foreign insolvency risk of brokers and custodians?
Okay, so Maureen Burke, Bank of America Merrill Lynch, representing FIA, and the committee's looked at some of these options here, and feel strongly that the amount that the FCM should not have to keep funds here in the states equal to the amount that's deposited at the foreign broker, that there are disclosure rules already in place, and maybe there could be enhanced disclosure rules to the clients on the risks on trading on foreign boards of trade. Understandably, that as the clients move into different jurisdictions, there's different bankruptcy regimes, there's different regulatory environments as well. But we do feel that there should be some level of an amount that the FCM should deposit, a reasonable amount for the margin obligation. So to not leave excess funds at the foreign brokers, either affiliated or third-party brokers, a reasonable amount. And there are rules already in place, which I think the CFTC has looked at this historically, that if the FCM has more than 150% the margin obligation, greater than 150% of the margin obligation, that you'd have to take the 5% broker charge against that amount. So, so those rules are in place. We support the rules. There are some jurisdictions that require a pre-funding in some instances, that the client has to pre-fund their margin. So that should be taken into consideration as well.
Carl?
Carl Gilmore from Penson. I tend to agree with Maureen's comments. Your earlier comment, Gary, about should there be some sort of requirement for creditworthiness of the broker or the intermediary overseas, I think that's a good idea. I'd be surprised if most of us are not doing that now on an ad hoc basis. So we're not just putting that money over there without some due diligence. So formalizing that, or perhaps making it an audit point, part of your risk-based audits, might be something that you want to do. Secondly, I strongly agree with Maureen's position on, I don't think it's a good idea to require the FCM to keep an equivalent amount of proprietary funds in the U.S. to secure the 30.7 requirements. The math just does not work out. If you go back to the selected FCM data reports that the CFTC puts out, I think our total risk-based capital requirement at the end of the last reporting period was approximately $16 billion. The 30.7 requirement was approximately $40 billion. So making the FCMs put in proprietary funds in an amount equivalent to the 30.7, in my view, amounts to a de facto raise in the capital of several magnitudes. And I'm not sure it's a practical way to protect those customers. And lastly, I do agree with the fact that we ought to limit the exposure and limit the funds that are held overseas to the margin required and some buffer. And the trick will be deciding on what the buffer is, because what's a reasonable buffer now in Europe, frankly, after what happened over the summer, is different than what it was last summer. So it's got to be volatility based, and it's got to have some kind of trigger that will be reasonable for the margin requirements.
Can I, just following on from, Gary, go ahead.
I should say, in addition to agreeing with what has been said previously, keep in mind that in many of the jurisdictions there already are a double option for U.S. clients already. So to the extent that a jurisdiction is a Part 30 jurisdiction, the clients already have an option either to have a direct relationship with a firm located in that jurisdiction or with a U.S. firm carrying its position omnibus into that jurisdiction. And certainly our experience has been that different clients choose different routes. Most clients want to have a single route for ease of administration, for ease of margining, et cetera, et cetera. I don't think it was among the questions you asked. I've always had a bugaboo that Part 30 potentially allows foreign brokers to have carry accounts for retail clients, and I've always thought that was something that should be corrected. I don't think it's taken advantage of, but it's out there. It's a loophole, and I don't personally like it. But for institutional clients, ECP type clients, there already are options, and I just think that in general, we're certainly not holding ourselves out as guarantors of a client's decision to trade overseas. The client itself has made that decision to trade overseas, and at least for us, part and parcel of that is we have to explain adequately what the risks are of trading overseas. But once someone has made that decision to trade a certain way overseas, there has to be an assumption of risk. We can't be in the guarantee business, or again, the economics will get even more
Let me
crazy.
just ask you, but is there a difference maybe between a customer wanting to take on a risk directly versus if doing it through the FCM not only affects the FCM and thus its customers as well?
Well, keep in mind that if a client goes through the U.S. entity to get abroad, there is a capital requirement in addition to that. The firm has to set aside additional capital, whereas if that client goes directly abroad, then the U.S. firm is not putting up additional capital. So there is economic implications already to that decision. I think the concern is, as Carl has said, is the idea of putting up, requiring us to have an additional amount of capital equal to the margin requirement, again, really skews the economics. I mean, and obviously that kind of charge would have to be passed back into the client. So in effect, you're going to be encouraging the client to have the direct relationship, and I'm not sure, as a matter of public policy, that's such a great idea either.
Just one further point back to the review of the creditworthiness. Then we fully support that there should be review, and that's the due diligence that we had suggested for anywhere where customer segregated or secured funds are held. So review of third-party and affiliated brokers, as well as the underlying custodial providers in the foreign jurisdictions. But and also on the double seg, or holding of the funds here in the States, there could be unintended consequences, as Gary's mentioning, that if clients feel they have more protection on the foreign boards of trade than they have for trading in the U.S., if it could force more trading overseas through the double seg arrangement.
Okay, thank you. And also, just a reminder, I'm not so good at reminding the housekeeping, but to say your name beforehand, so in the transcript we can pick it up right. Picking up on something that was mentioned, so enhanced disclosure, are we talking general? Are we talking specific? Who's providing it? Who's drafting it? Are we just talking about some general statement about going offshore?
Well, I think there is disclosure, and Kevin or Gary, I'm not a lawyer, so would appreciate the lawyers to step in here, but there's already disclosure requirements that the FCMs have. If, they can be reviewed to see if it is not sufficient. There's also the work that has been done by the law and compliance group, where they were looking at simplistically bringing it down to very simple language, which we discussed yesterday as well, the FAQs that, to provide to the client so they truly understand the risks when they're trading on foreign boards of trade and each jurisdiction. Every jurisdiction is very different. The bankruptcy rules as well as the customer protection rules are very, very different.
Yeah. I'm sorry. One thing that's been very, very helpful, IASCO in March of last year published a survey of the customer protection views of all the principal jurisdictions around the world, and certainly post the company whose name we cannot name, we have made that link readily available because that's something that people want to know about. So, FIA obviously has proposed an additional disclosure document that will enhance the already, robust disclosure, and I think, letting more folks know about this survey, will help the disclosure that's out there as to what are the various protections. I think that what surprised clients most in the recent episode was actually not the customer protection necessarily regimes. I think customers were aware, certainly institutional clients were aware that there were different levels of protections in different jurisdictions. I think that what surprised clients was the steps that have to actually go through to get the money repatriated back to the jurisdiction where their account began. And that's not unique to the U.S. If their account began in London, same issues. If they were trading Singapore, it might have to go through Hong Kong before it gets back to London. I think that was the biggest surprise. But I think that the enhanced disclosures that FIA is proposing will help make some of this stuff clearer.
Kevin, can you add color to the disclosure?
I think from the CFTC's viewpoint in the past, and I think from the firm's viewpoint in the past, there is a line to be drawn in terms of how much do you tell a client, do you hand a client up front to tell them to read and run the hook, or do you say, here are some risks, and if you're going to trade overseas, you ought to ask your broker about some of these risks and make sure you understand what those risks are. I think one of the issues that firms find is the documents, even now with all the disclosures, can be 40 pages long, 50 pages long, and I think I would be very surprised that, except for the larger clients that hire someone else to read these documents for them, that a client is going to sit down and read all this and understand it, and that's all right. All right, now I know. I mean, I think there really is. You can't downplay what those risks are, certainly, and hopefully the risk disclosure that's out there, the prescribed risk disclosure that's out there now, doesn't. I don't think it does. And certainly we should look to see what else more we should say, but I think we need to be careful not to pile so much information on clients that it actually causes them not to bother reading something than actually reading it, and then that doesn't help anybody. I think now that we have things like these links where you can say, if you want to know about this and you should know about this, here's a link, you read it, make sure you understand it, ask questions. But it's, I think there is that balance to be drawn on that.
In the, and again, I apologize for only having, but in your FIA piece, there's a footnote that talks about the ability in the UK to opt out of SEG. So what would you do with that? You pick one jurisdiction and one issue. What would you do with that with disclosure? Would you have a jurisdictional specific disclosure? Would you pick one and ignore other ones?
Well, our recommendation, that the ability for U.S. CCPs who open accounts directly with a UK 30.10 firm to opt out of the client money rules is pursuant to a CFTC order. I think it was in 2003. And our recommendation of the FIA recommendation is that part of that order ought to be rescinded. And my understanding is, and this is anecdotal, but that FSA is looking at changing that rule.
Mm-hmm. But use that as an example. Take something similar, but maybe not as, where you're not as strongly advocating it be changed, or something that's in the process of being changed? What do you do with it as a disclosure matter pending a change, or if it's assuming, you picked one out of one jurisdiction.
Right. That's the only one that I'm aware of. So I can't say there are others. There may in fact be, but I think if an ECP client opens,
But again, it doesn't have to be an election out of SEG or something. Just to use that as one example. I just
I'm
noted
sorry.
that in your fact, you picked one example to highlight. The rest was very high level, kind of general. I'm just trying to understand where, kind of how would you, and I understand the difficulties, but trying to find the right balance. But using that as an example, it kind of drives you, does it drive you towards jurisdictional specific disclosure? Do you stay at very high level? Where do you think it needs to go?
Well, I think on a account opening basis, it's high level. I don't think you can do that, because I think the IOSCO document that Gary referenced is 100+ pages. I'm sure it's at least that, right? I think the CFTC. No, I'm happy to be told wrong. I thought yours was like,
there's actually a convenient
CFTC's
summary table that's probably, it's 20 pages actually.
Okay.
It hits most of the main jurisdictions. The one matter that I do have to point out is that I'm aware this was provided from information from the different regulators overseas. I am already aware that at least one regulator's information may not be correct. So I think the regulators should also use this opportunity to go back and check what was posted on this, because clients are relying on this now. And as I said, I'm aware of at least one jurisdiction that information may not be correct.
So 2 things. First, yeah, I have some small familiarity with that survey, and it was at a particular point in time, and it was indeed based on what the regulators did submit at that time, but perhaps there might be some updating done. But to be sure, it's difficult to, unfortunately, unless you're CCH or the like.
Welcome to our world.
But Kevin, I just wanted to clarify one point. The point you were making on that was with respect to a 30.10 order. That was not, I believe, with respect to 30.7 accounts?
I believe that's right.
Thank you.
Okay. Well, let me move forward. So there was what about yeah.
Before we do, just one follow-up on disclosures. And yesterday we talked about disclosing the investments, the character of what the funds are invested in. I assume we would probably carry the same to the Part 30, particularly if it was in the U.S. and the funds were there. We would want the same level of disclosure on the underlying assets that they're invested in as well.
Stephen Winter, the only other thing I would suggest or that we should consider as it relates to disclosure is the fact that when clients open up an account, they sign the documentation, they get that disclosure, all the disclosures that they're required to either sign, review, whatever. But a lot of clients have signed those documents years ago and are living off that one-time disclosure. I think it would be worthwhile that the industry be required to send out updated disclosures at least on an annual basis.
Thanks. Okay, so it's coming. All right, so let me go ahead.
Now, just to add on the disclosures, I think one of the best practices we've talked about, which I think a lot of the firms are doing today, the brokers, is providing their underlying customers information about who they're actually facing or who they're using when they trade on certain markets. Because although they sign up with an FCM in the U.S., once they trade potentially on Eurex or on the OSC or a different market in foreign jurisdiction, the clearing member may be a different firm. And I think it's important to provide that information to customers so they understand, here's the underlying clearing member that my trading activity will be going through. And so they can determine if they're uncomfortable with that clearing member because they originally signed up with a certain FCM, that they have the option to direct that trading activity through a different broker.
Gary, I wanted to follow up on something you mentioned to get a sense of your firm and how it operates, and then something like Country Hedging and FC Stone. Because I think you mentioned something that's very interesting to me. The FCM, who's going to have customers who want to trade on foreign markets, will go through your organization, and then, as you mentioned, they may end up with an omnibus account in London, that will move on to Japan, and wherever. How does that normally work in the sense of, does the US FCM have the one account with a particular foreign broker that it uses, or does it go directly to, in an organization like yours that's multinational? And then I'll follow up. No. And I was going to just ask the general profile of a Part 30 customer relative to a 4D customer, and particularly like an FC Stone and Country Hedging. What do you see there? I mean, my general sense is I've always understood they're more institutional type of customers, but I just wanted to get your sense from 2 or 3 very different type of organizations.
Let me do the second question first, only because as much as for competitive reasons, I actually agree with Ross's views that you should disclose the affiliates, because most people come to New Edge, they want to trade with New Edge. In fact, I see anti-competitive reasons why you probably wouldn't want to require the disclosure of the ultimate foreign brokers, and that's because if the client of a lot of smaller firms were aware that they were clearing their account, that the smaller firms were clearing their accounts internationally with a Barclays or a New Edge, they'd probably say, why don't we just deal with New Edge directly? I think just disclosing the fact that there may be a non-affiliated or affiliated overseas entities, and on a request basis, I think that's a good idea. I think to mandate it automatically, again, I'm very fearful of increasing the concentration of this business. I just think it could be anti-competitive. From our perspective, we don't see a big difference between the clients that come to us to trade 4D and overseas, but that's our client base, where we're exclusively institutional. There are clients who come to us, by the way, who may want, they trade their needs. We're not telling them what to trade. They're the ones who've decided what they need to hedge, what they want to trade, et cetera, et cetera. So, part of the reasons why clients come to us is they know we have an international footprint, and they want to deal with us because they know we're physically present. They see that they're willing to take the group risk, okay, so to speak, even up to our ultimate parents. And so they just figure that everything's in the family. And they looked, in fact, to the ultimate credit ratings, even though the ultimate parents have no guarantee relationship with the subsidiaries. So, I think that's pretty typical in group organizations, that even though they're dealing with one entity, the clients tend to look at it as a group relationship. They obviously are looking at the specific entity. They want the specific balance sheet. They want the specific financial statements, but they're looking at it as a group relationship. And now, of course, because I answered your second question, I forgot your first question. Remind me again.
The first question would be, in your situation, would it be one-stop shopping for the FCM? Just go to one foreign broker, no matter what market it is?
Again, we're organized around 3 clearing centers, the U.S., the UK, and Hong Kong. That's just the way we're structured. And typically, we flow our Hong Kong account through our London account into the United States. So someone who's trading Asia will bounce twice. Someone who's trading Europe will come into London and then go through. So potentially, I'm trying to think, you could have as many as 4 stops. You're trading Singapore, you start in Singapore, you go to Hong Kong, you go to London, you come to the United States. But every firm is structured differently. It depends on how you're set up operationally. And as I said, there are clients that want direct relationships. There are things you can do in different jurisdictions that dictate where you want your account. Most of, we find that there's a great preference to house accounts in London, because I think London is considered to be a particularly flexible environment internationally to do a lot of transactions. It's not a distinction between the securities environment and the futures environment. Financing within the organization is easier in London. There's many, many reasons why we find that clients, more often than not, choose London as a domiciled account. But again, every firm works out their own operations to figure out what flows through, and regrettably, in many firms' case, it's a condition of history. So it may not be the most efficient. It's just sort of there. Many firms use different systems in different locations, and that drives it too. But but I think that's a description of sort of how we do things.
Jonathan Short, ICE. I just wanted to add one thought on the FIA proposal that amounts that were not needed for margining purposes on foreign markets be kept in the U.S. I think it's a good idea. I think it's probably something that should be mandated as an option for a customer. But, in the event that a customer has been given appropriate disclosure about the risks, I'm not sure it's something that should be a mandate that all funds be held in the United States.
Other views in response?
Julie from Country Hedging. I agree with Jonathan, but back to Tom's question regarding clients. For Country Hedging, we might have farmer producers who live in northern North Dakota, northern Minnesota, Montana, who want to hedge their canola in Canada. I mean, that would all the way up to, an energy company who wants to use an ICE contract to hedge their energy. So, we have a wide variety of clientele, and the disclosures we're talking about would, that would definitely affect them as far as what they were able to read and understand, and frankly, their willingness to want to do that. So, but I mean, the disclosures are a great idea. I just think different levels of clientele and different levels of sophistication will play into it.
Okay. Thank you. And this discussion about affiliates raises the affiliates question. And the use of FCMs and the using affiliate foreign depositories or affiliate foreign brokers. So should there be a concern that an FCM won't objectively analyze doesn't need to analyze the credit risk of its own foreign affiliate? How do we deal with the fact if one goes down, maybe they both go down? And, what are some mitigants about that? Are we concerned about the use of affiliates? Are there ways to mitigate the risk of them both going at the same time?
So we looked at this as well. Maureen Burke, Bank of America Merrill Lynch, representing FIA. And, one of the recommendations, once again, that we recommended was that the FCMs should have procedures, due diligence procedures for monitoring any depository, custodial account, affiliated, and third-party broker. And the depository custodial accounts that should be monitored in a comparable manner to third parties. Regarding to prohibit an FCM from using an affiliated broker overseas would complicate things. Many clients want to come in, as Gary had mentioned, and deal with one counterparty. We do, from a Bank of America Merrill Lynch perspective, we have we have memberships all around the globe where a client comes into Pierce, and then we face off versus affiliates. We have much more information available to us about our affiliates, the internal controls, policies, and procedures. We can look at that on a broad basis and see that there's equivalent policies and procedures in place with our affiliates. We're going through a third-party broker. We're not privy to that information. So there's things that we know by dealing through an affiliate that we do not know by dealing through a third party. And go ahead.
Ann Bagan, CME. So to your point, Maureen, and I just throw this question out, yes, you have a lot more information for your own affiliates, but what's the likelihood that you're not going to actually use one of your affiliates? And that you go to an unaffiliated third-party foreign broker. What's the likelihood of that? And I don't know, so I'm just asking.
Let me say it the other way. We set up the affiliate because, in fact, the clients have wanted to deal with our footprint globally.
Right.
So it's not that we choose to, it's not like we have a random choice of affiliates. We've set up the affiliate structure in the first place. And in response to client demand, they want the convenience of being able to process all their trades through a single entity. And there's lots of flow-through information, the operational information, and frankly, in these days of PTG trading, you get more real-time information as a result of dealing with your affiliate than you would possibly get through dealing with a non-affiliate. So, there's no doubt that there's some clients that prefer this, or some clients that don't prefer this. And in this world, the good thing is they have their choice. But it's It's not that we choose our affiliate, it's more that we're pushed to set up an operation in that location.
A quick question, Maureen, following. So, and I don't remember, but is the policy that you call for in your write-up, is that publicly available? That's available to customers when they come in? Is that, or is that just internal policy?
The policy of the review of the due diligence?
Yeah, well, how you'll choose your counterparties. For instance, if say, well, we'll consider custodians and affiliated counterparties who meet a certain criteria, which is, is that?
So the recommendation as it stands right now is that there would be written policies and procedures that would be available to the SROs and the CFTC. We did not get to the point of putting it out as for public disclosure to the clients. And as I mentioned yesterday, this is a work in progress. It's a living document. We're working, with the industry as a whole. There are some concerns on making our, for the FCMs to have all your due diligence policies and procedures public, and then having a client rely upon that. And there's also, Chinese walls within the firms, that there's things that are done by our credit department that may not be able to be disclosed with Chinese walls. So there's some concerns there, and I don't think it's been fully formulated at this point in time. It is a living document. I don't know if anyone else.
So let us assume, for the sake of this discussion, that firms in looking at their affiliates will do so with the utmost in due diligence and objectivity and bona fides. Let's take that as a given for this sake. In the event that there is a failure, for whatever reason, lightning strikes at, say, the U.S. firm, what is the likelihood that those affiliates will not themselves also fail within a period of days?
I mean, realistically, I think it's low.
And Gary, you were talking about, and forgive me for picking on you, but
not the first time.
Well, the honors are even, I think. But you mentioned that there would be, earlier you talked about people just seeing the complications in particular instances, which I shall not name, of how things go in terms of having to get money back. And you also mentioned that you folks are, and I'm sure there are very important efficiency reasons, organized so that if it's going through various places, there might be intervening 1, 2, 3 entities. If heaven forfend, and I'm sure this is not, in any way likely, but just hypothetically, a firm so organized failed, in order to get that money back, you'd have to be going through at least 2, and in some cases maybe even 3 or 4 insolvency proceedings. What's the impact there?
Sure. Well, first of all, that has nothing to do potentially with doing business with affiliates or non-affiliates, because you don't know how those non-affiliates are organized, and they may be organized the exact same way. I mean, firms choose to organize how they process what I call, there's the remote markets, there's the central markets, and then there's the 2 big markets, okay? I mean, there are a lot of remote markets that clients want access to. And to have a direct omnibus account. I mean, part of what drives the way we're organized, frankly, is the large trader reporting requirements of the U.S., because we're trying to set up the flow through in a way that we can actually get the information the most timely and efficiently. Okay, and one of the reasons we've set up our operations, and we've done a lot of reprogramming in the last couple of months or last year or so, is to make sure the information flows through in a way that we can get it to you guys as efficiently and as accurately as possible. So part of what's driving our flow-through process is, in fact, an effort to comply with other regulatory requirements. Okay, but the specific issues that you are raising are just go with the territory. Even a non-affiliate that, I mean, we have 2 issues. For example, let's suppose we want to access the markets in Vietnam, and I'm not even sure they trade futures right now. But let's just say I know they trade securities, and that's why it's on my mind. I probably don't want to have a direct relationship with a Vietnamese company. I have a hard time doing a credit analysis at this point. Maybe I'm concerned. I would much rather do business because it fits my internal credit policies with a Hong Kong entity that itself brings in Vietnam and is willing to stand behind its Vietnamese subsidiary. So in that case, right off the bat now, I'm going to have a double, if not a triple, potential bankruptcy situation, because it's the Vietnam company in Vietnam law, it's Hong Kong, it's the U.S., whether I use an affiliate or not. Okay, by granting access through the U.S. portal, okay, you're bringing in inevitably different bankruptcy regimes. That's just one of, you got the clients have to weigh the pros and cons of doing business in certain ways. I mean, obviously, there's efficiency, there's margin, there's single margin, there's potential financing. There's all sorts of benefits to having the single account, but there's obviously, as we recognize, certain detriments. You can alternatively find a Part 30 jurisdiction and open up your account directly there, but that's not as convenient. You're dealing with different time zones, et cetera. I mean, there's pros and cons for each alternative, and that's why, at least for the institutional clients, and certainly it's the case in the last 4 months, I find that certainly the legal and compliance teams are becoming much more involved in the discussions with potential clients as to how things work out there.
Gary, just following up on that then, if we do, you go forward with, we're going to trade with affiliates and use affiliated broker-dealers, which from my past, I mean, I totally get why that would be appropriate. But would then there be reason to look at the 17H filing, and maybe we need more disclosure there so that we at least have the opportunity to look at what are the intercompany funding and financing relationships, what are the intercompany receivable payable, and look at it from that perspective, and maybe that way we can get better insight into it.
As Maureen said, I mean, I think these type of issues are certainly important to discuss, and I think, as regulators, it seems fair to me you'd want to know more about how groups work. Certainly, there are other regulators that we are subject to that certainly want to know that kind of information, so I don't see a big objection. Obviously, it's the level of detail that we go down, but yes, I mean, I think, there are certainly regulators around the world that want to know about where we're getting liquidity from, where we're getting capital from, what's our commitments, things like that. They want to know that structure. Again, there is a fine line, though, because I do think there's an anti-competitive aspect of this. The disclosure that's made to you versus the public, I think, and it's not that we wouldn't make it on a selective basis, but general disclosures, I think, could be somewhat embarrassing. If clients see that a big firm is clearing through another big firm, that's embarrassing. If a smaller firm is clearing through a big firm, then the clients are wondering why they're not dealing with the big firm directly, but the big firm may not want to deal with them. I mean, it gets a little complicated, and that's where I get nervous, and I just don't know the answers.
Okay, thank you. Other thoughts?
Carl Gilmore from Penson. Just one quick follow-up. I think Kevin makes a very good point, just sort of going on Bob's original question. My view would be that it's doubtful that using an affiliate just for clearing and settlement, in the same way that you would use a third party, it's doubtful that that activity in and of itself would increase Bob's domino effect. And so I think it's really important to point out, as Kevin says, if you move out of clearing and settlement traditional activities into funding and financing, that's the touch point, in my view, where you may increase the risk where one affiliate goes down and then the others go down one after another. So essentially, I think you've got two different questions there.
Okay. Let's move back to, and it's slightly, because of the FIA point, a slightly different question, but to the extent that a foreign jurisdiction's regulations provide for differing degrees of protection for customer funds, should FCMs be required to elect the most stringent regime offered? Should FCMs be prohibited from opting out of protection, going to that point? And if not, how should the related risk to the FCM be mitigated?
To the extent that the foreign jurisdiction offers a more stringent regulatory regime for customer protection, we strongly feel that the FCM should take the most stringent protection to be offered to the coming in through the U.S. FCM. And to the point of the opt-out, the U.S. FCM should not be able to opt out their client base trading through 30.7 accounts. We should take and the FCMs should review the jurisdictions, understand the rules. I think the CFTC should perform a thorough review of each jurisdiction and understand the related rules, as well as the SROs, and that should be part of this disclosure going out to the clients. But it should be the most stringent approach.
Seeing general agreement? No disagreement? Okay.
Dan Driscoll, NFA, I would agree with that completely.
Okay. Let me ask, what additional reporting should be required from FCMs who deposit customer Part 30 funds with foreign brokers? What kind of reporting? We've talked about disclosure. We've talked about limitations on how much goes. What kind of, and we talked, Kevin raised generally, is it kind of the same thing as yesterday, but what specifically, what kind of reporting should be available, I guess, either to the SRO, the Commission, and to the, available to the customer base?
Dan Driscoll, NFA. My opinion on that is that I think any sort of reporting that we think is appropriate for U.S. business should be adopted for the Part 30 as well, and basically in the same format, in the same level of detail, unless there's some specific reason that it can't be done or it's not practicable. But I think anything, and I think we all agree that more information should be submitted to the SROs, and much of that should actually be made available to the public.
What about country-specific? Anything dealing with specific things going on in the country?
Maybe you can explain what you mean by country-specific.
Sovereign risk, sovereign occurrences, anything that needs to be maintained, or is just kind of a sort of a transactional kind of notice, your FAQ or whatever, and periodic information about what's going on a transactional basis, and leave it. Go ahead, Gary.
I mean, again, I think that, you know, it depends on the way, it depends on the nature of your business. I think if you're directing your clients into a foreign jurisdiction for trading purposes, then you probably have some kind of additional obligation to affirmatively disclose events in that jurisdiction. But for clients who are themselves choosing to be in that jurisdiction, it seems to me that they are generally aware or should be aware of what's going on in that location. So I'm not sure what kind of disclosure. I mean, obviously, you know, if there's something material that the domiciled FCM needs to disclose, I think it would disclose that in the ordinary course. But I don't think we should go beyond the walls and require the same type of disclosures perhaps we are required to make in the local jurisdiction by the local affiliate to different jurisdictions. I mean, I think it's, you may do that, but I think to require that probably just becomes information overload.
Okay. Carl.
Sorry, Carl Gilmore, Penson. Gary, was your question disclosure to the public, or was it disclosing additional information to you, the Commission? I'm sorry, I didn't understand the question.
It could be either one. You know.
I think the problem with a disclosure requirement is that to do it, you either got to do it wholesale or you have to do it not at all. And the problem is that if you don't want to get into a situation where each of your participants is making its own sort of analysis as to what the risks are, sovereign risk, what the risks are in that country, the political situation, et cetera, et cetera. What I would urge the Commission to do in that point is to make sovereign risk or country risk or activity in each company or country a point in your risk-based analysis of all of the registrants. So I think it might work better to come from you based on your view as to what's happening out there in the world, to ask the registrants what their activities are in that country, rather than some sort of wholesale disclosure, because I don't know what it really gets. And I'm going to have a website with 200 countries and my analysis of each. It probably works better to come from you out to the registrants rather than require some sort of overall risk disclosure on a country-by-country basis. I think it becomes too unwieldy.
Okay. Dan Driscoll, NFA, on the reporting issue country by country. When the Part 30 rules were first adopted, there was a provision in there that said that all FCMs had to report on a quarterly basis, their positions on all of these markets to NFA. And we got a lot of documents over the years, but in about 10 years that rule was effective, there was one economist from the U.S. Department of Commerce that once a year would call and ask for information about those reports, but nobody else ever did anything with them, including really NFA, except to receive them and make sure we stored them. And ultimately, that rule was repealed because nobody could think of the use of it. So my view on that would be on country-specific things, not to require ongoing, regular reporting of that information, but if there's something going on in a particular jurisdiction or a particular exchange, that the regulators ought to have the ability to call for that information to review it. Because I think if it's regularly filed, it'll just add cost and paper, and I'm not sure anyone will really use it on an ongoing basis.
Going back to some specifics, and again, I think another issue covered off in the FIA thing, so maybe it's a quick discussion. Should FCMs be required to include the foreign futures and options positions of both U.S. domiciled and foreign domiciled customers in the Part 30 secured amount requirement?
Maureen Burke, Bank of America Merrill Lynch, representing FIA. Yes, we strongly believe all clients should be included in the 30.7 on a net liquidating value basis.
Okay. And maintain. Oops, sorry.
Gary, I would just add that I think that most firms do this today, and that to not do it would actually increase operational risk to try to peel away the non-U.S. persons, non-U.S. firms, and hold them into a different calculation. That would actually make it more complicated to do these calculations.
And do I get a similar answer to something like maintain all funds received from U.S. and non-U.S. domiciled customers as margin for foreign futures and options in a Part 30 secured account? Same. Okay. And you may want to ask about this. Should Part 30 secured accounts contain only foreign futures and options positions? And what transactions other than foreign futures and options positions are carried in Part 30 secured accounts?
Yes, we feel that that they should only include the foreign futures and options positions. The cleared swap positions are now mandated to be out, I think, effective November 8th. And, so for the regulators, the FCMs, to clearly be able to identify the accounts that should be within the 30.7 account, we feel it should be, some of the rules should be changed. In some instances, we made recommendations. The SROs can make some of these rule changes, by a matter of best practices, but we do feel the rules should be changed to make it explicit.
Ann Bagan, CME rules actually do require that any of our cleared OTC products be held in a separate origin, the sequestered origin. So we're already not allowing them in 30.7.
And to be very clear, while I know there were some issues before April or May of 2010 as to what one could do with cleared swaps. Effective that point, we, and this was even pre-Dodd-Frank, did establish a rule permitting putting the cleared swaps into a cleared swaps customer account. But because at that point we did not have the power to require this, we said it would only work in the event it was there pursuant to a DCO rule. And so that is something that could happen today for any DCO clearing swaps. That does not need to wait on November 8th.
Right.
Dan?
In terms of other types of positions that, in accounts that might be held in the Part 30, it's my understanding that one or more of the firms that are both registered as FCMs and RFEDs, have put some of their OTC retail FX positions and accounts in Part 30 because of the fact that there's no segregation or Part 30 treatment under the Part 190 rules or the bankruptcy code, and that gives them some solace. They think that that there's some that there may be some protection there. So I think I agree that it should only be Part 30 accounts that go in there.
And to be very clear, whatever solace anyone's drawing is a bit of a false comfort. Indeed, what they're doing is enhancing the protection of the Part 30 customers.
I don't disagree with you, Bob.
Okay, thank you. Okay, so let me turn it over to Gary for a minute, who wanted to talk to us, wanted to talk about, I'll let you even introduce this as China system.
Yeah, I was just, as some folks know, Gary DeWall from New Edge, we maintain we're one of the few authorized FCMs that's authorized to maintain a joint venture in the futures world in China through our entity CITIC New Edge Futures Co. Ltd. And as a result of that, we have come across a regime that has interested me for some time, and certainly in light of current events has interested me regarding how they oversee funds protection in China. It's interesting to look that way for information, but I sort of like to get information anywhere. China has had its own problems with FCMs. Pre-2006, they had a number of insolvencies that caused them to institute regulations and additional protections. And they basically have a customer protection regime that maintains three core elements, one of which I think is worth just noting for the record, and we will submit something into the public file either later today or early next week. China is a pre-trade margin jurisdiction, which means that clients can only trade if they have the money up front. That's not something that we think necessarily should be exported. China has an investment protection fund, sort of like CIPIC. It's something that might want to be studied. For my own knowledge, I don't think it's easily exportable, but it is a regime that has an insurance protection system for the futures markets. But the element that I do think is worth studying is something called the China Futures Margin Monitoring Center. And this was established in March of 2006 in response to what I said were a number of insolvencies in China. And effectively, it's a company that is overseen by the CSRC, which is their equivalent of the CFTC, and the General Office of the State Council. And it's owned by the four principal commodity exchanges in China, Dalian, Zhengzhou, China Financial Futures Exchange, and the Shanghai Futures Exchange. And effectively, what this organization does is each day they receive feeds, electronic feeds from both sides of the market. They receive feeds from the Futures Commission merchants, so for example, my organization in China, and they receive feeds from the depositories of customer funds, the exchanges and obviously the custodial banks. And effectively, through software that they have, they do a daily reconciliation between the two. China is an interesting jurisdiction because, in fact, it's this entity that also issues customer statements officially on behalf of the FCMs, and that's an element that I don't think is readily exploitable. But what's interesting, though, is they do get information that effectively allows them also to do a reconciliation between what the FCM is saying should be in segregation versus what the underlying records say should be in segregation. So there's a reconciliation between the segregation calculation and underlying information, and then there's a reconciliation between that amount that's required to be segregated versus what the depositories are independently reporting as in segregation. So, if you go back to how this could have been useful, and China is a no top-up jurisdiction, so you can't top up the amount in segregation, so there should be an exact match. And they recognize, of course, that there'll be some variations because of the various issues that we discussed yesterday. But if you think about this applied to our circumstances, and you think about the trustees report in the firm that we can't name, obviously there would be an early warning that maybe the excess is declining, that there's a potential violation of segregation. I mean, there are elements of the law that are odd because, again, once CFMMC sees a problem, it's supposed to refer it to the local office of CSRC where the FCM is located, as well as the headquarters in Beijing, and CSRC then has 5 days to respond, which, I'm not sure is probably the right time frame. But again, this, to me, is a very, very interesting regime, and I might mention that CSRC is funded 100% by the 4 participating exchanges. But it's something that they believe has prevented them from having a repeat of their FCM default situation because of invasions of customer funds. And I do think it's something that is well worth the SROs in the United States as well as the CFTC to look at. Again, I don't think everything of the system works, but there are certainly core elements of the system that are very, very interesting. And from an operational perspective, I don't think would impose a lot of operational burdens on folks, because the electronic feeds are things that we make available or use already for other purposes.
Thank you. Any reactions?
I have Ann Biggin. I've got a couple questions for you on that because I know you were going to talk about this. First is this a real-time system or it's as a point in time? It's real-time?
No, it's as of a point in time. Okay. All the firms are required to provide this information. I believe it's by 5 p.m. each business day. By the way, I forgot to mention that one of the interesting, why this is becoming very topical is because, as many may be aware, 3 pilot FCMs in China have been authorized to, in theory, to trade outbound. And these will be the first FCMs in China that will be authorized to trade outbound. And they'll be authorized to trade on LME, ICE, and CME. And the firms that are competing to get the business will have to sign up to the system. They will have to provide information. They're trying to, CFMC right now is trying to figure out how to get information from the non-U.S. brokers. I'm sorry, the non-China brokers to feed into the system so that they can extend the protection of CFMMC to the overseas business.
Okay, my other questions are, Sandy made a point yesterday that a lot of your customers deposit checks, and that you have a lot of very small banks out in the farmlands or wherever. And I don't know if that's the same structure that they have in China, but there's going to be a lot of, I would assume, reconciling items or things in transit. How does the system handle those?
I mean, again, it's a remember, China is a pre-margin trade system. So the money is in-house in advance. As I said, not everything can be exported. It's not the systems are different. As I said, officially, it's a no top-up jurisdiction. But to me, I don't know how you have a no top-up jurisdiction, frankly. But it is a no top-up jurisdiction, so there are parameters. But again, you have to look at and take the elements. Unfortunately, and I do thank the folks folks at CFMMC, they actually did prepare something which they've authorized me to submit into the record. It is in Chinese, unfortunately. My staff in China was kind enough overnight to do a literal translation, which probably needs to be a bit refined more to ordinary English. But I think for purposes of starting a discussion, it's a good document. We'll get into the public record.
I just worry, I mean, I think the system sounds really interesting, and certainly people have brought it, this idea to us over the past few months. I just worry about, given the way our industry is structured here in the U.S. with all these small banks and checks and that kind of thing, if this system can really work for us, but it's an interesting concept.
If I could
Dan.
just put my 2 cents on this. Dan Driscoll, NFA. So certainly in NFA, we believe that at a minimum, it'd be good if we had sort of standing instructions where FCMs have to give standing instructions to depositories to give us information at least on request, so we don't have to go to the firm and get a separate confirm every time we want to do that. And it's we've talked about, and it's intriguing about the idea of getting regular electronic feeds or electronic access. I do think, though, then if we had that, or we could have it, you need to worry about security, obviously, because this is very sensitive information. You need to have systems to do something with this. You know, if you have constant electronic access, you can't afford to just occasionally look at it, because I think there's concern that if you have the information available to you, you're supposed to be doing something with it. So we would have to figure out what we would do with it, how often we would analyze it, and create systems to coordinate with that. But it's a very intriguing sort of process, and I think it's just a question of how far you go down that line.
Gary.
I mean, again, without repeating my general speech from yesterday, I do think at the end of the day, you know, the clients in our business deserve additional comfort and additional, assurances that their money is safe. And obviously, there are a number of alternatives that will come out of this debate. And I think that as we look at all the alternatives, it's critical that we consider the fundamentals of the business, of which one of the most important aspect is, maintaining the viability of the FCM model. And so, yes, I agree that there's an invasive element to this, and yes, my own colleagues in my own organization are probably going to get ready to lynch me when I walk back. But I do think that, we're going to have to make not only we are going to have to evaluate each of the alternatives for their benefits, but we do have to consider the costs on the system. And at least intuitively, to me, you get a lot of protection with this, relying on a lot of the already available infrastructure. And so to me, that's one that doesn't really upset the economics dramatically. I mean, obviously, everything has an impact, but given some of the other alternatives, which fundamentally change how things are working, and I'm not even sure, hearing all the legal debates yesterday, you actually get as much protection as people are bargaining for. This isn't a good alternative to be looking at and perhaps adapting to the U.S. model.
Maureen Burke. So on the point that Gary's making here, as we've stated, the committee has gone through initial review and recommendations. This should be reviewed as well as other alternatives. If we can enhance the customer protection model in any manner, it should be reviewed, and we'll look to review this. The feasibility of it, we know that it couldn't happen overnight. And understandably, there would have to be some sort of system set up in order to take the information in, to analyze the information. If there's disparities, changes, it could not be done overnight. But even with the changes that were made on for the LSOC model and the reinstatement that third-party custodial accounts are permitted, it's something that should be used there as well. So that, there's online systems, electronic feeds, so we know that there isn't any unauthorized, the flip side of that, unauthorized withdrawal of funds by the custodian back to the clients, which introduces risk to the FCM and the system as a whole. So, in the day and age that we're in, we do need to look at technology enhancements to provide the transparency and enhancements to the customer protection regime.
If I could ask one question. So I know Dan raised some important security issues. Is it, assuming that one has appropriate password and whatever protection, is it practicable to give some third party, say a regulator, a self-regulator, essentially view access to what the balance is in an account that would be, say, in this case, held by an FCM for its customers?
I think the question becomes more related to what's the level of detail that's being provided. If it's summary level detail at a customer seg account at a bank, that's fine. But I think if you get into more detailed information as to who might be behind that, clients, things of that nature, that would be problematic.
I'm sorry. So balance then, yes. Transactions?
Again, what would be the benefit of the transactions being there? But I think it gets back to bank secrecy rules and protection of customer information. And so as long as it's summary that doesn't allow somebody to take advantage or get access to information at a customer level, I don't see that as being a major issue, but it would have to be reviewed by the banking regulators.
Ann Bagan, my issue is just knowing what the balances are in a seg account is only one half of the pot, right? You got to look at what the actual liabilities are to the customer, because without both sides, how much is in a seg account is totally irrelevant. It doesn't give you any comfort or any solid information unless you know that it's enough to meet the obligations to the customers.
Also, as a matter of practicality, when you guys do inspections or the regulators come into do their inspections, they look at our segregation computation. They're going below just the segregation computations, look at the trial balances. You're in fact looking at the ins and outs. So to a certain extent, you're getting that information upon request to begin with. The only issue is, in what form do you want it? But certainly, when our third-party auditors at the end of each year confirm stuff, they're not asking us to give them the information. They're going directly to the source to get that information. So that practice is sort of out there. So technically, can it be done? Of course it can be done technically. The issue is what kind of protections you want to put around it and how frequently do you want to have that information. But again, it's technically a lot can be done these days.
Okay, so why don't we take a 15, where? Oh, go ahead. Sorry.
Hi, that's okay. Julie from Country Hedging. Speaking on the technology, I guess as a smaller FCM, we have concerns on what kind of burdens this additional technology would put on a firm our size, that where a larger firm might be able to bear that burden more easily than a firm our size would, as we have less customers, to help us try to recoup those expenses.
Okay, understood. Anyone else?
Sandy McCarthy with FC Stone. I just want to make a comment that I don't know how comfortable, I think we would have to disclose to our customers that we were granting access to the government so that they could see the wires. And I don't know how comfortable some of our customers would feel about that.
Okay, let's take a 15-minute break. Let's come back at 5 after 11. One thing that's obvious is a lot has happened since the mid-'80s when the Part 30 rules were adopted and changes needed. There's agreement on what many of the issues are, and we'll be working with you all towards changes that address those issues. So the FIA paper is very helpful in the Part 30 part. Not sure that we're there on all the recommendations, and I know you're not all the way there either, but it does surface many of the issues in this space, so that's great. It shortens our conversation. So we're going to, unless there's other issues in this space that panelists want to raise, we'll end this session and then pick up the 1 o'clock session on the duly registered FCMs and BDs. So are there other issues people want to raise right now in the Part 30 space? No? Okay. All right, well, thank you all for your help and your participation. Thank you so much. And we'll pick back up promptly at 1 o'clock. Okay, let's get started. Welcome back to the Roundtable, second session today, as we continue to look at various issues and ways of enhancing customer protection. In this session, we're going to look at issues that are particular to duly registered FCMs and BDs. And in case you don't know it, the top 10 FCMs, 18 of the top 25 FCMs, based on customer seg held, are duly registered entities registered with CFTC as FCMs and the SEC as BDs. So to help us explore these issues today, of course, all of you, but I wanted to point out that we have John Ramsey from the SEC and Grace Vogel from FINRA. Thank you for joining us. So let's quickly go around the table. Again, each panelist telling us their name and a company affiliation. Gary Barnett, CFTC.
Tom Smith, CFTC.
Kevin Piccoli, CFTC.
Oh, John Ramsey with the Securities and Exchange Commission.
Dan Driscoll, NFA.
Carl Gilmore, Penson.
Stephen Winter, State Street.
John Nicholas, New Edge.
Grace Vogel, FINRA.
Katie Turklat, Foley and Lardner.
Bill Terrell, Bank of America, Merrill Lynch.
Robert Lee, Deutsche Bank for SIFMA.
Mark Holloway, Goldman Sachs, Chairman of the SIFMA Capital Committee.
Christine Cochran with the Commodity Markets Council.
Bill DeLeon, PIMCO.
Ann Bagan, CME Group.
Great, thank you. And then Bob Wasserman is going to return later on in the session. So FCMs and BDs, FCM BDs are in the business of handling customer funds, and as we discussed yesterday, and Bob will touch again a bit upon it today, futures customers' funds are handled under one part of the bankruptcy code, while securities customer funds are handled under another part, and we'll hear it. You've been talking about that yesterday. There'll be more today. But while the entity in bankruptcy faces different parts of the code which separately address its futures and securities customer funds, the entity is still nonetheless a single individual company, a single legal person that faces an overall insolvency risk. Thus, risks to the enterprise which might compel an insolvency could come from the future side, the security side, or for some other risks, perhaps risks which arise from other activities of the entity, or even risks created by affiliates of the entity from a parent or other entity that in one way or another puts the registered entity at risk. So in that light, let me ask the panelists, are customers currently getting sufficient disclosure to understand the overall bankruptcy risk the various business lines of a duly registered FCMBD are creating for that entity? Do you understand my question? Is that so people just getting information on the futures line, but they're not hearing about the securities side, or vice versa? What kind of information are they getting? Are they getting the disclosures they need to understand the risks to the entity? Who can I, Carl, you want to give me a try at that?
Thanks, Gary. Carl Gilmore from Penson. As a general premise, I think that what has happened in the practice in the in both the securities and the futures industry is for bankruptcy disclosures to be activity specific. So a futures customer gets information on Part 190. A securities customer will get information on SIPC and what happens in the case of a broker-dealer bankruptcy. But I don't think currently that there is a lot of overlap for multiply registered broker-dealers and FCMs? And probably I think there ought to be. That's a great question.
So, and let me back it up. So pre-bankruptcy, I should make it clearer. So pre-bankruptcy, when I'm facing a company, it may or may not be stressed at the time, but let's say it's a company that's under stress, but it may not be, let's say a futures customer, entity's under stress from some other part of the business. Is there enough information about other parts of the business getting to it, or are we just focusing information from one part of the business to the people who are being served by that part of the business?
I think traditionally that the way most of the firms have organized themselves is that the bankruptcy information is, again, it's specific to the type of activity. So if the question is there enough information about what the implications are for a futures customer if they are in a SIPC bankruptcy, or what is the implication for a broker-dealer customer if something on the futures side causes the firm to become insolvent? I think probably not. So one of the things that we ought to think about, and this is why I think it's such a great question, is for firms that are multiply registered, there probably ought to be more crossover bankruptcy information available out there, frankly, in plain English, which is why I like that FIA's FAQ touches on that a little bit. I think that's a great first start.
Great. Other views, please?
Yes.
Katie.
I'd like to touch on what we mean by disclosure as well and how it's communicated, because we've got, I think there can be improvements to it, and I agree with Carl that it's something we need to address. But we've got, when you open up your futures account relationship, you're handed this set of disclosure documents, all of which, if any customer actually read it, they'd probably say, my God, am I crazy for even opening up a futures trading account? And that says to me that most customers don't read it or glance at it. It doesn't sink in. Yes, I think there's still a benefit to providing it. There are some who will. I think it's also sort of protective and to the benefit of the FCM BD to have provided that, even if the customer doesn't review it. But do we need to be thinking of how we get the disclosure out there on sort of an ongoing basis? Is it available? Should it be available on a website, the company's website, or the clearinghouse website, or the CFTC website, but something that's sort of available on an ongoing basis? And part of what I factor into sort of how I'm now thinking of this, I think there was a lot of confusion in a recent bankruptcy matter where a lot of customers were under the impression, an incorrect one if they actually read the bankruptcy disclosure statement that they're given, that the clearing system also protects and makes whole the customers of a defaulting FCM. And that seems to have been a fairly common misconception. Now, in some instances, it may be sort of willful ignorance, but I think with others that there really was this impression, and part of it may have been based on some of the rhetoric that maybe historically we've used that may oversell credit clearing.
No, I hear what you're saying. Thank you. Let me, two things. First, housekeeping, because I failed to make and you were very good about it. Thank you. So the disclaimer of the unnameable. So in light of our Division of Enforcement's ongoing investigation, we cannot engage in a discussion concerning matters involving MF Global. So I ask each of you to respect this necessary rule, that we not inject MF Global or specifics about MF Global into the discussion here today. Second thing is just remember for the court reporter and the transcription and all to state your name and your affiliation, or state your name when you go to speak. And then let me just go back, wind back again for just to make clear. So we heard today in the earlier sessions the need for more information to customers, more information, so whether it's reporting or notices, and so I fall into the term disclosure, but I should call it information, whether it's reports and notices of various types. So what I heard from FIA in certain respects today was that certain things should be mitigated by more information. We can't, certain things we should bulletproof in some ways to some extent, and other ways it should be handled by giving more information to customers. So I guess the question is, in that vein, even before you get into the music stopped and you're in an insolvency proceeding, just in terms of the normal operating business, but businesses come upon stresses, in these enlarged notices and reports that are being made available, are we thinking that the futures folks are going to see the futures notices and reports? Are they going to be on, as Katie's suggesting, some website that, so there's more of a picture about the company? Is that happening, or is it still kind of bifurcated so that one side sees one thing and they're blind to what's going on elsewhere in the company? Or to the extent things are already being reported, not enlarged reports, but the futures people don't see what the securities side of the business is providing. Grace.
Are you assuming that the customers are professional or institutional customers as opposed to retail customers when you ask the question?
No, can't assume that, but it's a good point. Go ahead.
Because I think that it would be very difficult to have a disclosure describing the bankruptcy regimes that a retail customer could understand. I think there are so many complicating factors here and so many unknowns that I can't imagine how you would ever draft something that a retail customer would be able to understand.
I think, in my experience with our company, I agree with this gentleman that the disclosures tend to be divided primarily along product lines. So if you have a customer that opens up a futures account, they're going to get futures disclosures and securities disclosures, because a lot of the disclosures are product specific. They just wouldn't make sense otherwise. But that being said, I will say that before 2008, we had very few inquiries at all from customers about bankruptcy issues and customer protection. After 2008, we certainly had more, and then in the last 4 months, we've had quite a few, and I think that's probably very reflective of the industry generally. I think customers want to know the differences, want to know about customer seg, want to know about bankruptcy protection, and I think there's a significant appetite out there for that type of disclosure, and we went ahead and drafted a sort of a comparison document. This is what happens on the security side, this is what happens on the futures side, and it's been fairly well received, but obviously not mandated, but maybe something like that would be worth doing, where it's just simply a chart. This is what happens on the securities regime, futures regime, all on one piece of paper.
Okay. Yes.
Hi, Bill DeLeon, PIMCO. I think that, as Grace pointed out, that you can't have full disclosure on what it means for bankruptcy. It's just too complicated, and I think the amount of disclosures you would have on that, because it would be a firm's interpretation, would just make it a lot of paper and not a whole lot of value. I understand the concept that you want to protect the individual versus not being aware, as well as the institutional investor. What I think is important, though, is, as John pointed out, you want to have certain information available that's easy to obtain. And I think that in our experience, certain questions we've asked have been less easy to get the information than you would hope. So, for example, you may say, how do you invest funds, excess funds, or how do you manage your funds? And the answer that it's compliant with 1.25, while it's legally correct, doesn't give you a whole lot of information. And I think that there are multiple, or what controls do you have in terms of processing things? And we're fully compliant with SRO rules. Doesn't give you a lot of information. So I think that while those are truthful answers and they're not meant to be bad, I think that especially given the new framework we're in, with more collateral being posted, more questions than what we've seen in the last 4 months, and then again 3 odd years ago, I think that there's more focus. So I think that what would be helpful is sort of more guidance or force in terms of what needs to be disclosed, as opposed to, well, we've answered that, thank you. If you don't like it, you can take your business elsewhere. So I think that there's somewhere in between, and just in terms of negotiating with people, we've seen that. And that be one of my concerns, is sort of the bar for what needs to be disclosed in more than just broad strokes of we meet this requirement. For example, do you use internal repos or not? Well, if you wanted to find that out 6 months ago, not everyone would have told you the answer or would have given you a meaningful answer. So things like that are where I think people are very concerned and focused on what and how are people doing things. And while you don't want to necessarily see how the sausage is made, you do want to know some of the ingredients as opposed to it meets the standards.
Thank you. Thank you. Yeah, John.
Before I say anything, I should get the disclaimer out of the way. It just occurred to me, if I say anything interesting or noteworthy, it represents my own views and not those of the commission or my colleagues on the staff. The reaction that I had was that it's hard. Coming from the SEC to argue against, more and better disclosure, and maybe there should be more, some thought about that as to the application of sort of bankruptcy laws generally, sort of on either side of the aisle. But with respect to how those things work, with respect to a duly registered firm, the points of confusion that people, particularly are somewhat focused on today as to how the bankruptcy regimes operate alongside each other in the case of a duly registered firm, and how claims of customers on one side or the other sort of are resolved vis-a-vis each other. Those things are confusing, not, I think, just because they're difficult to understand, but they just may not have clear answers. So I don't think you're probably going to, or at least in some respects, may not have clear answers. So I think with respect to those kinds of questions, you may not make that much headway by trying to draft disclosure that will sort of give people better information with which to sort of make a decision about whether to go into a jointly registered firm or not. That may be more a question of sort of all of the stakeholders working together to sort of resolve those things in advance to the extent we can.
How about in terms of the kinds of information we were talking about yesterday, Dan, the 4D topic, and talking about the amount in SEG, the amount required for customers, the excess. I mean, should the securities customers see that? Should the futures customers see more on the security side? Should there be issues regarding the failure to, under SEG or under cap, that sort of thing?
Dan Driscoll, NFA. In a lot of those things that we talked about yesterday, I think in the final analysis might very well be posted on NFA's website. So they're available to, to anyone that comes to our website. And I suppose you could have some sort of notice to securities customers by broker-dealers that information is available there. But my idea would be, if you have information that's publicly available and posted, it ought to be publicly available to anyone that finds it helpful.
Let me shift directions then, totally shifting directions for a second here. Currently, BD FCMs are permitted to compute the required capital under each standalone business, and then are only required to maintain the larger of the two, not the sum of the two. Does this approach, should this make sense? Should it change? Should the Commission amend the capital rule to require a duly registered FCM broker-dealer to maintain a minimal level of regulatory capital equal to the sum? What do people think about the way the capital rule works for duly registered entities?
Yeah, Bill DeLeon, PIMCO. I think that you need something in between, that the current method is probably low because there is correlated risk between the two, and having sufficient capital for one entity or the other is not enough. Taking the sum, I think, is too extreme because that assumes that there's no offset between the two. So I think that would be too high. However, there is that intersection. So I think you should view it as the higher of the two entities themselves, and then whatever the cross product would be if it was a combined entity. And that would be the right way to look at it, because to the extent that you need a minimum, you could have a situation where, imagine there's only one position in one entity and one position in another. They could be going the opposite directions. So you can wind up with zero, And I would argue that's the wrong number. If you took the sum of the two, that's clearly the wrong number because there is an offset. So I think you need to sort of think about something in between.
Great, thank you. Okay, other thoughts on it? Dan?
Dan Driscoll. You know, my thought on this is that the CFTC computation and the SEC computation, while they're, I think, both designed to tend to increase as the firm's business increases, they're measuring very different things. And I think ideally, you would like to have something that measures the risk of the entity that would require probably some more harmonization between those two computations. It's simple to just add two numbers that people already compute, but it doesn't necessarily get you to the right number.
Grace.
Yeah, Grace Vogel from FINRA. I think that on the security side, we've looked at the minimum capital requirement as a leverage limitation, whereas we use, with respect to the customer business, and we use the haircuts and other charges to limit the firm's proprietary business. So there's a bit of a mixing of apples and oranges here. I think that what we need to do is really start with a clean sheet of paper and revisit what the capital requirements should be for broker-dealer FCMs. We need to factor in leverage, and we also need to factor in liquidity. If we look back at the problems that we've had in the industry, they haven't been caused by not insufficient capital at firms. They've been caused by a run on the firm, which is caused by their inability to liquefy positions or to obtain funding. So I think a fresh look at the rules is appropriate.
Thank you. Katie?
Yeah, I would agree with that and with the need for harmonization and quite apart from measuring different things, even in the areas where the same things are being measured, there are very different conceptual approaches being taken. For example, cleared swaps would be an example where, if I correctly understand the SEC's position, they're treated effectively as back-to-back swaps by the broker-dealer. And so if it's under margin more than one day, you may have to take a proprietary capital charge, whereas in the CFTC capital rule, it increases your risk capital requirements when you're clearing on behalf of either a customer or an affiliate, which is a very different approach, and you don't have sort of a proprietary haircut. You may have an under-margin haircut at a later point in time, but just very different conceptual approaches for dealing with what seems to be the same risk.
Yes.
Hi, Mark Holloway from Goldman Sachs and chairman of the SIFMA Capital Committee. And I'd like to pick up on the comments that Dan made and that Grace made. Many of the firms on your list are what we would describe as full-service FCMs and broker-dealers, and as a result, these entities conduct many product lines. And if you were to look at our capital computations, picking up on what Grace said, the overwhelming majority of our capital requirements relate to penalties for illiquid assets, haircuts on our securities positions, and other penalties associated with our operations. The either or greater of situation pertains just to the minimum capital requirement. And I think for a lot of the firms represented here, if you were to look at the totality of our capital requirements, the minimum is a small part. And so I would just, again, to come back to what Dan said, if you were to look, and again, I'm thinking of the larger multi-product firms, at the risks that we face, I think one could believe that neither the CFTC minimum nor the SEC minimum really addresses or is a reflection, if you will, of those risks. And the clean sheet of paper approach is probably a good idea.
Thank you.
Ann Bagan, CME. This certainly is a topic that has been under discussion for many, many years, and I suppose you could say it's kind of a tough argument to say that you shouldn't have enough capital to cover both sides of your business. But that being said, it has been in place for a long time, and if we were to do a combination, we are probably stripping our firms of some of the capital efficiencies that they have in place by being a combo firm. I actually looked at a number of our broker-dealers to see if they could withstand this type of aggregate, and probably most could. But again, that's going to really affect their business model and business activities.
Thanks, Ann. Other thoughts? Yep, John.
Yeah, excuse me. I guess I would echo what Mark and Grace both said in terms of focusing on on liquidity. Not that I think minimum capital standards may not be an appropriate thing to talk about. It's just I think in terms of investors' interest and our interest as regulators in making sure that firms don't fail because of a run-on-the-bank scenario, liquidity really is the key measure. And certainly for the largest firms, for our alternative net capital firms, we require those firms to, or we expect them to have sufficient liquid reserves so that the broker-dealer can sustain a fairly significant stress event over a 30-day period, and there are certain parameters around how it is one defines that. And I think the largest firms in general maintain that plus some amount. There may be other classes of firms or types of firms where some sort of specific liquidity standard or requirement we ought to think about, because I think you want at least to make sure that the firm stays alive, even if it ultimately fails, long enough that you have the ability to take steps to transfer customer funds or assets or do something else remedial while you have the chance.
Thanks, John. Other thoughts on capital? You should.
Kind of reiterates what some has already been said, but as I said yesterday, I think liquidity and capital are really the key issues, and I think at the end of the day, the idea of going with a clean slate is the right approach, but you need to look at it from a perspective, again, of what is the business model of that entity in total, and what's the liquidity needs of that. I would make the analogy that's what we do today in the futures world when you come to margining. One of the factors in determining how much margin you put up is liquidity of the underlying product. And so why wouldn't you consider that as part of the capital computation as well?
Thank you. All right, I'm going to move to another topic here. Okay. Grace, can I just, and Kevin, could we just talk quickly about what information is currently shared between DSRO and your analog regarding the examination of dual registrants?
Okay, I'll start. It's Grace Vogel. We make available through a report center that we built at FINRA all of the examination reports of our dual member firms and the responses to those examination reports. That's routine, so the DSROs can pull that information out at any time. We also coordinate through the IFSG, which is the Intermarket Financial Surveillance Group. We meet either once or twice a year to discuss general topics of interest, more on the policy side as opposed to about specific firms. When there is an event or a concern about firms, there's then an active dialogue and routine sharing of information. So if there's something in the news that's concerning, we'll give a call and get, pay collect information on any given day, information about operational issues. I think it's hard to generalize, but it's we do have a memorandum of understanding that allows us to share all information that's available to us.
Ann Bagan
Yep.
again from CME. So I agree with everything that Grace just said. We do try to coordinate and have joint reviews, but it's a lot harder than it sounds because we do have schedules that are going out. That being said, though, from our side, and I'm sure FINRA does the same thing, is we do review those reports that are coming out of FINRA on the broker-dealer side to see if there are any ongoing concerns that we perhaps should follow up on during our reviews. And then, as Grace said, we do have a lot of discussions and information sharing regarding joint members.
Okay. Yeah, are there things that are obvious to you or occur to you that would allow you to enhance the coordination or information sharing that goes on? It's fairly informal right now.
I don't think I'd say it's informal because we do have this IFSG agreement. There's not routine sharing. As Grace said, it comes about when either we're about to launch an audit or there's a situation in the news. And perhaps that's one way that we could enhance is to have more routine discussions. But I can always call Grace and get her, and we get the information we need. So.
Okay. Okay. All right. Let me jump back into a more difficult question, and John, you might have some thoughts on this. I mean, BD FCM gets into a stress situation, no technical violation. This is a hypothetical. So BD FCM gets into a stress situation, no technical violation of SEC or CFTC rules is occurring. Given the fact that these regulated entities are holding customer funds, should the regulators publish advisories, have greater power to say game over, require the transfer of assets, or what do we do in a situation where we've got no technical violation, but we are in a on the edge situation? How does the regulator handle
Well, I mean, I guess my off-the-cuff response is there may be other things that we ought to think about doing, but I think But the first thing I would think about doing is once we're aware that there is a problem or that customer funds or securities could be in jeopardy, is to make sure that we are on site at the firm in force and are able to make sure that all of the controls around the protection of customer assets are there and are working. Because after all, that is the way the customer protection regime is supposed to work, is to give some assurance that even upon the failure of the firm, will be able to either transfer assets out in advance of the fact or pay customers off relatively quickly and easily. But I certainly, so I don't know how much one could do publicly that, but certainly, joint efforts on site in appropriate circumstances always make sense. Identifying firms that we think may be at risk even before a point where it's obvious to the world that it could be a problem, but at least where there may be metrics suggesting that a firm is vulnerable, making sure that we share that information whenever we have it and deal with those situations jointly. And when I say we, I mean not, sort of the SRO, DR, as well as the primary federal regulators.
In connection with the SRO, yeah. So what powers does FINRA and CME and does an SRO have vis-a-vis its members in that sort of a situation?
Okay, so it's Grace Vogel. We have rules that allow us to restrict a firm's business, and we have rules that allow us to force a firm to reduce their business. Restrictions could take the form of not increasing their inventory, not taking on new correspondence, not hiring any more registered reps, not opening any more branch offices, and reduction of business takes the form of asking firms to, reduce their inventory, to reduce haircuts and increase capital, or to reduce the number of customer accounts they're holding. We have used this rule in selected instances. We don't use it routinely, which is good. But we have it, and we do use it when we need to use it. I think that it would be helpful to be able to have a stronger regime in place that would allow us to force a firm to move the customers out of the broker-dealer while the firm is still in compliance with the rules without going through a bankruptcy proceeding.
Ann?
We have similar rules on our books, and I agree you want to take whatever actions you can pre-bankruptcy so that your hands aren't quite so tied. But we have required firms in the past either to not withdraw any capital while they're going through a stress situation, or not to reduce seg funds, again, stress situations, without our approval first. And we have used that power from time to time, and in concert with the CFTC, we've done that with some firms. But yeah, we can make them reduce their prop business, move customers, restrict some of their activities if we deem it necessary.
Bill, you had your hand up before.
Yes, thank you. I think it's important that while there are certainly controls in place, and I know you can't talk about what happened 4 months ago, the things we lose sleep over and are concerned about is what controls and how real-time are they, and how do you identify stuff? Because we've had questions with many FCMs and BDs on what they're doing, how they control things, how they audit things. And to the extent that while we understand there are a huge number of movements and wires, and it's a non-trivial aspect, we're very concerned, how do you self-audit in a timely manner? And a full audit of 3 months is not really a very warm and fuzzy thing when you saw what happened 4 months ago, or when we saw what happened in 2008. And given additional concerns, that's where we're concerned and most nervous is how do you ensure that you have controls in place to prevent sort of the fraud or negligence events, and how do you flag them and how do you reverse them? And obviously there was a interesting article in a widely read paper this morning about something that happened. So seeing that and going, okay, that's great, the money was in the right place, and then all of a sudden it magically isn't. How do you prevent and control that, and how do you stop it? And that's, in terms of what we're most concerned about, to have a prevention of a repeat. We want to see more expanded powers or more improved reporting requirements to help identify this, because clearly the model works in terms of the box until it breaks. So how do you make sure that the records are clean and you can track things down? And that's something we're very concerned about, and I think it differentiates one firm versus another. And to the extent that firms take that upon themselves to do it, it's great. However, if we're really trying to come up with a systemic fix here, we need it to come from above, to have higher minimum standards and to give the SROs the ability to say, you do this or else.
Ann Bagan again. I just wanted to back up on one thing. To your question of should some body put out warnings, if you will, publicly for a firm that's in stress or crisis, whatever. I think we have to be extremely careful in that situation, because we don't want to cause a run on the bank, right? We don't want to be the cause for suddenly customers wanting to flee a firm when potentially these are rumors, and the firm is stronger than what the press perhaps is saying. So I think you have to be very, very careful about being the one to say, hey, everybody, watch out for this firm.
Yes, sir.
Hi, Bill Terrell with CFTC Capital Committee. I would suggest to you that most of the larger firms are subject to various stress tests. We need to, most of the firms are subject to various stress tests. They need to have plans in place to be able to react to various conditions. And to answer your question about what the regulators could do, I guess I would question is what exactly are the plans that you have in place to act very quickly in order to stifle any run on the bank or get in there before it gets to the point where it's overwhelming. And, what coordinated effort is there among the various regulators to, to have, a immediate reaction that's going to be beneficial to the industry? So I would suggest, if anything, that there should be a similar type of stress test, if you will, among the regulators, identifying various firms and go through some scenarios. What if? What if this firm goes down? What are we going to do? Who are the firms we're going to reach out to transfer the clients, and how quickly can we accommodate that? And to Bill's point on controls and so on, I would agree. I think most of the exams that are being conducted today are very strict to the regulations that are out there on the books. And although the SEC has a process of going around and doing with the ANC firms a process of evaluating and giving feedback, I think it'd be very helpful also to do something along the lines of what is the best practice, where can we improve some of those things without having the penalties of the examination and enforcement and so on. It'd be more of an encouragement to the firms to try to get their standards up to a level playing field, if you will, as opposed to always trying to dodge regulations and figure out how to comply with the minimum standards, because sometimes they're overwhelming. You don't have enough time to figure out what's the best practice.
John Lothian. So when things are going wrong, there's a tremendous amount of uncertainty. And to your point earlier about disclosure and all, something that could be helpful in the field of uncertainty when something bad is about to happen would be knowledge of the path that the firm is going to take should it be in bankruptcy. So it's almost like a DSRO type of a question. Am I going to go, SIPA, or am I going to go through Chapter 7? Okay. So, for example, in the firm that shall not be named, it's a lot of people out there that are saying, this is a commodity firm, not a stock firm. It had 400 commodity accounts and 38,000 futures accounts. It's a futures firm. And there was a tremendous amount of uncertainty. It was a big curveball when it went the way that it went. And so maybe one of the things that firms need to disclose even before they get into trouble is which is the regime that they would pursue. Maybe it's their decision as opposed to the regulators.
It's
Yeah, Bob, and I think you have some thoughts, Katie, too, but yeah.
And so, speaking, of course, purely as to the statute, rather than any particular hypothetical or historical situation, SIPA, the Securities Investor Protection Act, is fairly specific on these issues. And so they have, essentially, if you have a member of SIPA, which has a customer who can be satisfied by SIPC advances, then you are, for reasons which I can go into over the next few minutes, going to be going into a SIPA proceeding. Essentially, the way it works, Section 5 of SIPA, if either the SEC or one of the securities SROs is aware of facts which lead it to believe that the firm is in or approaching financial difficulty, it shall immediately notify SIPC. So financial difficulty. At that point, SIPC may file an application for a protective decree. And they would basically do that if they believe that the member has failed or is in danger of failing to meet its obligations, and one of a number of conditions is met. And those conditions are that the firm is insolvent, is the subject of a proceeding in any court in which a receiver, trustee, or liquidation for such debtor has been appointed. And so in other words, that would cover, for instance, a bankruptcy of that firm or some other receivership proceeding. is not in compliance with the applicable requirements under the 34 Act with respect to financial responsibility or hypothecation of customer securities, or is unable to make such computations as may be necessary to establish compliance with financial responsibility or hypothecation rules. So under those circumstances, essentially, SIPC would go into the district court, and the district court, upon receipt of that application, shall forthwith issue a protective decree if the debtor consents or if they find that one of those circumstances is the case. And upon filing of the application, or pending the issuance, the court shall stay any pending bankruptcy or various other proceedings and the court shall have exclusive jurisdiction. And so, moreover, there is another provision, which I don't have as handy. Basically, a member of SIPC, before filing a bankruptcy, must obtain the permission of SIPC. And so what you have is, based on SIPA, that statute, any joint broker-dealer FCM, and it's not a predominance test, it's, is there a securities customer? Is there one, I mean, as I read the statute, if there's one, and no matter that there be a million commodity customers, if there be one securities customer, then you're likely going down this path. Now, it's possible, I suppose, that SIPC could decide not to invoke this. I guess, I don't want to speak for them, but it strikes me they may feel, well, look, we have a duty to that 1 or 400 or whatever security customers.
What happened in the Sentinel case? How was that different?
Sentinel was not, to my knowledge, a member of SIPC.
I can confirm that. This is Katie Turkla. They were not a registered broker-dealer, not a member of SIPC, and not even treated under the subchapter 3 stockbroker liquidation provisions. But the stockbroker liquidation provisions in the bankruptcy code at the end of the day have a very limited application. Any broker-dealer that's basically has public customers and is required to be a member of SIPC, you're in all likelihood facing a SIPA liquidation proceeding, and effectively you're limited to broker-dealers that may be intrastate, where they're not registered as broker-dealers with the SEC, or where they may be offshore, which was an issue that came up in Revco, where one of the offshore entities, not a registered broker-dealer, was nonetheless deemed a broker-dealer for subchapter 3 liquidation purposes.
So the short of it is, for instance, in any hypothetical case, the CFTC does not have the power to say, look, this is mainly a commodity firm. It really should be going into a subchapter 4 proceeding. The statute basically puts all of this in the hands of SIPC. Now, the statute also says that a SIPC trustee has the duties of a trustee in Chapter 7, and in particular, if it's a commodity broker, subject to subchapter 4, the commodity broker provisions, to the extent this is not in conflict with SIPA. I am not aware of any such conflicts that have come up in recent history.
Yeah, I was just going to, Bob, your recitation description sounds right to me, and I was just going to sort of try to boil it down in terms of my understanding of the Commission's responsibility, the SEC's responsibility in the case of a failing broker-dealer entity. To say that under that SIPA is the one means that Congress has prescribed to try to rescue customers' funds and secure the positions of customers in entities that that hold broker-dealers that hold customer funds for them. And then in a situation in which a firm has failed or is failing, can't calculate, provide reliable calculations and there's reason to think that customer funds are in jeopardy, the Commission is in fact duty-bound in those circumstances to notify SIPC. SIPC, if it determines that those are in fact is the case, is duty-bound to go into court. And the Commission, in fact, if it does not, subject of another controversial case, is may be obligated to go to court to force SIPC to do so. So that's the scheme that we have. It occurs to me as well that regardless of what regime a trustee is operating under, where you have potentially two separate customer estates, that trustee is always going to have the challenge of sort of how do you manage those to provide equity on both sides, and that would be the case regardless of which specific title you're going into court under.
And I should note that in meeting that challenge, because it is balancing to the extent there's any tension between those estates, I mean, certainly we would be participating in such proceedings, and we have the right to appear and be heard, and would be definitely doing so to ensure that that tension is resolved, in a way that is appropriate for the protection of the commodity customers.
Yeah, I would just say that this was a greatly misunderstood specific area where more clarification from the Commission would have been very useful. As long as we're taking shots at the press, it's been misportrayed in the press then, because it was as if the CFTC had a choice in the matter and that they declined, which has portrayed them as the redheaded stepchild of the security side. And so, I don't like to see my regulators portrayed that way. So you guys, some clarification would have been helpful.
Katie.
Yeah, maybe moving sort of a segue to another topic we may be covering, but in following up on John's comments, I do find myself wondering, are there things, and I fully appreciate sort of the bandwidth constraints all around, but are there things that can be done across the CFTC, the SEC, and I think SIPC itself needs to have a place at the table to have a better sort of agreed upon understanding of how the different pieces work together, a better understanding or communication of how the commodity broker provisions are intended to work. I think almost of a memo of understanding type approach, so that prior to the next bankruptcy situation, where the last time you really want to be sorting out these issues for the first time is when you're trying to deal with the crisis. Are there things we can do to sort of improve the communications? And I fully understand that there are differences in the statutes. There are always going to be ambiguities, issues that are going to come up, disagreements. But to the extent that it's possible to try and foster a common understanding across the CFTC, the SEC, SIPC, on how this should work when you've got a duly registered FCM BD, and that could perhaps even address issues of how do you deal with the myriad relationships that a firm will have with customers, where they may have a prime brokerage account, they may also have a cleared futures account, they may also now have a cleared swaps account, they may have a variety of other relationships either directly or through affiliates that I think need to be recognized and can complicate or pose challenges when you're dealing then with the bankruptcy and managing that kind of situation.
And so I guess you raised 2 points. So the first one, which I will seize upon, there are indeed bandwidth constraints in the sense that we have a limited budget and a lot of work to do with very little money comparatively. And yes, that would be nice, but there we are. Having said that, this is critical, and it is something that there was some work that was done in the aftermath of Lehman, which was the first broker-dealer FCM insolvency, and there was indeed work with the SEC and with SIPC in terms of understanding how things should work, and for instance, first day order, which is very, very important. I wish I could say it was done perfectly and completely, but that would not be the case. We have more work to do. It is work that we are doing both continuously as, shall we say, there are certain issues that have us in consultation currently, as well as planning for the future, and, you know, as well, and to tack back to issue that came up with yesterday in our discussion on the bankruptcy code, you know, as well with, for instance, colleagues at the FDIC. And so there's a lot more to be done, and we are attentive to it, and we'll do it as best we can.
Okay.
Yeah, I would just say for our part that we certainly welcome the chance and opportunity to talk about, anticipate these issues as much as we can. There are various forums that could be appropriate. I know there's there's a joint advisory committee that has been used as venue before for issues of sort of joint mutual interest to the two agencies involving matters like this. That may be one possibility, but I certainly repeat the point about limited bandwidth because I'm feeling that at the moment too.
Thank you. Okay, so maybe a follow-on question. So given some of the risks we've discussed, so we've got bankruptcy issues, we've got the capital, we've got issues about information. So here's hypothetical. So given the various risks we've discussed, should FCMs and BDs be separate legal entities?
Sorry, I didn't hear the
Should FCMs and BDs should they continue to exist in the one business, or should they be separated?
John Nicholas from New Edge. I mean, I think there's some good arguments that they should continue to be the same entity. I think customers seem to like the fact that they can do securities and futures in the same legal entity. I think that it, paves the way for portfolio margining, which I think would be something that would be terrific in this market, something that's available overseas. I think that dividing the business would make life less efficient and more complicated for customers, and probably result in perhaps more risk-taking in terms of customer positions. They're dealing with two counterparties. They may be less inclined to put on a hedge, for example, that they would do if they only had to face one counterparty. So I think there's a lot of good arguments for keeping them together.
Others? Carl?
Carl Gilmore Penson. I echo John's comments. It's the 21st century. These markets are intertwined, like it or not. The futures markets affect the securities markets affect the futures markets, the OTC markets affect all of them. And so my view would be the small benefit that you might get from separating a broker-dealer from an FCM in terms of potentially ring-fencing any problem is far outweighed by the costs and the inefficiencies in the marketplace based on how these markets in this country have evolved. So I think I don't see any real good reason to separate them out.
Grace.
Grace Vogel. I would venture to say that most of the large firms have customers who are both futures customers and securities customers, and having both products in the same legal entity actually serves to reduce the risk of the combined BD-FCM as opposed to increasing the risk.
And I would add, I think I would question the premise that it may actually simplify things in a bankruptcy context or in addressing some of the other issues, because if you do separate them, you're going to have to be dealing with issues on an intra-affiliate basis, because it's not going to stop the practice of wanting to transfer excess funds out of your prime brokerage account over to the futures account at a separate entity. So I think you introduce another set of issues that can complicate things. I would also, just from sort of a legal perspective, and thank you for mentioning the sort of portfolio margining. You know, Dodd-Frank did add specific provisions to both the Exchange Act and the Commodity Exchange Act, finally to accommodate portfolio margining for futures and securities, which presupposes that it's, you know, a duly registered firm. So.
Thank you. John?
John Lillian. Looking at it from the customer perspective, what we've seen in recent years is the entrance to the retail side of the business are people that have come out of the securities side of the business. So it's some of the retail stockbrokers or even option brokers that are now offering futures, and customers are flocking to that. So voting with their feet, that's a growing thing. And as I mentioned yesterday, there's some ways that customers are taking advantage of the insurance protection on the securities side with their excess margin. And so unless futures has a level playing field when it comes to that, I would expect that trend to continue, and that you'll see firms, more and more firms that are predominantly stock firms, securities firms, as opposed to futures firms that you're regulating.
Bill.
Yeah, Bill Terrell, SIFMA Capital Committee. I would agree and echo what Grace and Katie had mentioned earlier. I think actually you, in terms of liquidity risk, I think you actually introduced more liquidity risk. I can tell you years ago, dealing with a firm that had a separate FCM and a broker-dealer, we actually would use a funding vehicle or a funding entity to bridge the two. So you're actually introducing a third entity into the puzzle in order to facilitate the client needs, which are really spanning across both of the FCM and the BD with their products and their requirements. And having separate two entities with two different margin regimes and possibility of not having a complete view of the client introduces more operational risk, and funding of those capital requirements and so on starts to, again, introduce more liquidity risk across the whole entire entity.
Thank you. Yes.
Gary, this is Christine Cochran with the Commodity Markets Council. I just wanted to chime in on this one because we had a very, very heated conversation amongst our members on this topic. And I'd like to say that we, as an organization, would support what's been said here, even though I don't see very many of my members sitting around the table. But I should point out that we did have some of our FCM members who supported the idea. As an organization, we have not endorsed it, but it was a very heated conversation back in December for us.
Separating. Yeah.
Hi, Bill DeLeon, PIMCO. I just want to echo what many people here have said in terms of the separation is sort of a difficult situation, and a couple of anecdotes I'd like to point out. First of all, a lot of corporations will have separation of legal entities, but they'll be shells without any actual capital. So unless you have a guarantee from the parent or look through to other legal entities, you're actually in a worse off situation because it's going to be less capitalized or more likely to be orphaned in a bad situation, i.e. the good bank, bad bank type concept. Another thing to point out, which is I know it's been was in the original rules, and sort of there's been talk now about cross-margining. Originally, if you look at the futures model, and if you look at CME, for example, you have commodities, equities, fixed income, and currencies all in one pot. And then with derivatives, they were put into a different pot, and then each different derivative was put into another pot. You wound up with a situation where you had no cross-margining benefits, which drove up the margining requirements. So I think that that is less efficient for capital usage as well as for clients. I think that two other things I just want to add is, one, when you have more legal entities, you have more due diligence and more wires and more inefficiencies there. And most importantly, I think that, when you use different type of entities, the investor needs to be aware. Am I using 4 different type of agreements, and do I have 4 different type of risks or one? And I think that you can't fix that. That's up to the client and what they're trying to achieve and how they manage things. So you can't fix everything by making different legal entities. What you can, and this went to the earlier point, is making sure that the rules are sufficient for capital and segregation, and that they're followed on a real-time basis. And those are the important things, and more important in my view, than just arbitrarily splitting things out without these other controls in place.
Thank you. Yes.
Stephen Winter, I would add one other point, and that's when you have a combined broker-dealer FCM, the decision-making process is also different within the firm, because if you're an FCM standalone, all you need to concern yourself with the rules of the FCM. But when you're both, now you have to concern yourselves with the rules of the broker-dealer as well, because they do impact each other. And so I think that actually creates a higher standard for them.
How so?
Well, for example, and FINRA can attest to this, but any of the banks that are, for example, expanding their FCM to get into the swap clearing business, need to make sure FINRA is comfortable with that. Where, if it was a separate entity, do I need to go to FINRA?
So do you end up
I
with
can elaborate on that if you'd like.
Sure,
It's,
yes,
Grace
please.
Vogel. We have a Rule 1017 that requires firms to get our approval when there's a material change to their business. So we would view that if they are entering into the derivatives business, that would likely be a material change in their business, and we would have to review the process, the controls in place for that business.
Can you explain a little bit 1017 and what is the scope of a material change to the business?
I think that it's facts and circumstances based.
Well, some examples maybe, just the types of, some generic.
If a firm is getting into the market-making business for the first time, or doing underwritings for the first time, doing private placements, if they're historically have had an institutional clientele and now they're getting into the retail business and opening up branch offices.
Got it.
We would include derivatives, as Steve said. So if a firm has been.
Could it include taking on a new? It could include taking on a new business line.
Yes, it does include taking on a new business line.
Okay, and would it include maybe a significant change in the financing? In the capitals, in the way the company's financed.
If
so
there's
a big kick in terms
if there are
of leverage.
changes to the capital structure or ownership of the firm, that is required to be approved by us. If it's a material change, we have a different rule that requires withdrawals of capital to be approved as well, which would include the payment of dividends.
Got it. Thank you. Yeah. So I guess, Ann, do you have anything similar under your membership?
Rules for material changes?
Yeah.
Yes, we do. We do
Okay.
have that as well.
Okay. All right. Okay. So,
Sorry, this is Robert Lee, Deutsche Bank for SIFMA. Just following up on the various points about portfolio margining and given that, in the future as we start seeing more and more products that, go into clearing, I know a lot of products are already being cleared, but we have this whole new OTC swaps and security-based swaps that would be, subject to mandatory clearing in the future. I think one of the things that, I think people have alluded to is that Dodd-Frank has sort of bifurcated, certain product classes even within that, space, such as CDS, into swaps and security-based swaps. And to the extent that both those products, index swaps, which are swaps, and single-name CDS that are security-based swaps, are being cleared by the same clearinghouse and by the same client, I think that is an area where I think portfolio margining probably should be looked at very closely, or as one of the first things to be looked at, given that the indices are essentially a basket of individual single names, and when you have a credit event for a single name, and it also constitutes a constituent in the index, they will settle at the same price and at the same time. So from a customer perspective, I think there is a great demand and desire for portfolio margining. And I think, and to be able to achieve that, not only would the CFTC and the SEC basically allow for it, but the second step, and which is more of a practical issue, is that you need to have probably the same legal entity that clears for them. So given that, Dodd-Frank says that you clear swaps for customers with, FCMs, and on the SEC side, you can't clear for customers, on security-based swaps with an FCM. You may be forced to look at a duly registered BD FCM to be able to achieve this. So I just wanted to get it out there.
Great, thank you. Katie?
I fully agree with everything you say. I think there's a real demand for portfolio margining. I think there are some issues that need to be worked through in terms of the legal analysis, and so it is important, I think, for the SEC and CFTC to be coordinating on addressing those issues, including, depending upon the choice of the account structure, if it's held in a 40F segregated account or in a securities account structure, how does the bankruptcy code regime apply to those accounts? And, I know ICE Clear Credit in their petition, they've addressed that issue. I know other clearinghouses are looking at providing portfolio margining and also carefully evaluating those issues. But in light of recent events, I think it's very important to actually have a clear understanding of what would happen in a bankruptcy context and how those accounts would be treated. But I would also add that short of portfolio margining, I think we have to assume that even without portfolio margining available, the firms that are going to be providing clearing for CDS as swaps and CDS as security-based swaps are going to be duly registered. They're going to be participating in one of the clearing houses that's both a DCO and a clearing agency. And I think there are some basic issues in terms of account structure on the securities side where there is, I think, some potential uncertainty. And I'm thinking in particular of the general framework for securities under 15C3 and Rule 15C3-3, which applies generally to securities, but then the separate provisions specific to security-based swaps in 3 Cap E of the Exchange Act, where in the cleared security-based swap context, the language is virtually identical to what was added to 40F for cleared swaps. And the SEC, I believe, in addressing sort of the compliance and effective dates, identified that as one of the provisions that took effect or could take effect without further rulemaking. But I find myself thinking, is there something inherent in the 3E language that almost requires that for cleared security-based swaps that it has to be held, sort of the funds, separate from other funds for cleared securities? And that's not a position I'm advocating, but I think there are some interpretive issues and some issues where the marketplace and FCMBDs would benefit by greater clarity on, are you working under the 15C3-3 framework? Are you working under the 3 Cap E framework? How do the two interrelate, just as a basic threshold matter to be able to sort of implement client clearing for security-based swaps?
Yes.
Sir, just maybe to complicate things even further, for European, CDS, they do have restructuring as a credit event, and to the extent that it's a name in an index that has a restructuring credit event, it doesn't automatically get triggered. It's still up to either the buyer or the seller to trigger. But what happens from the index context is that it's actually spun off into a single name. So you go from what used to be a swap now into a swap plus a single name, a security-based swap. So
I will not try to complicate things further because this is a very complicated area, but I would just say that I think my view, at least, I would say probably the staff's view, is that ultimately, we imagine an environment, a world where there is a legal construct to be able to, and the regulations support the concept for having as much portfolio, stuff that is reasonably related to each other that can be portfolio margined together, held together, and put in the same account, in a single account. And we, I don't think we think that there is anything in the statutory scheme as amended by Dodd-Frank that would preclude that. But it's, there's a lot of individual steps to get there. The thing on the table that seems to be of most interest to market participants now is cleared swaps and security-based swaps, CDS market in particular. So that's what we're focused on as a first step, and have been working with staff at the CFTC and others to try to make that happen. So I think it's going to be a process, and I think over time, potentially the pool of things that could be dealt with on a portfolio basis may expand.
Thank you. Tom, you have a point you wanted to...
Yeah, I'd just like to go back to where we started in the conversation with disclosure. And now that we've had the benefit of hearing the complications of portfolio margin, complications of a dual registrant bankruptcy, if anyone would like to elaborate maybe on their previous thoughts on disclosure, how can we make effective disclosure for all these types of issues that are with the firm with respect to, I'm a customer, I want to trade either on the future side or the security side or both sides. What should I really understand about this organization? How can we do that with all of these complex issues? Is it just a very high-level type of disclosure, or do you look at what type of business you're going to conduct? So I just want to see if anyone had any further thoughts on what we talked about at the very beginning.
Hi, Bill DeLeon. I think what needs to be disclosed is what regulatory bodies each unit falls under, and to the extent that there are certain customizable things that are permittable, you need to have some disclosure on what they're doing along the spectrum. And I think that those are the important things, so that there's some reasonableness when you ask a question, okay, you're doing under 1.25, or can you give us more details? Or, how is your margin held? Is it held at your bank? Is it held at another bank? Those things should be easy to obtain, because you want to know, okay, soup to nuts, what is this person doing with my money? If I have funds with them in a prime brokerage, you're kind of behind the wall there, and that's structural in the prime brokerage. But you want to make sure that if you open a futures account, it's clear. Is it part of the PB, or is it part of the standard futures agreement? And those sort of things, I think, are where people get in trouble and don't necessarily always know or aware that a PB relationship is completely different than a futures broker or a securities account. And that's where I think people get into trouble. And I think that, the rules are very clear, and there's a lot already publicly available in terms of if you're in one of these entities, what type of protections you get or don't get, why you may get better rates or not. It's the question of, do people know which entity they really are in and how things work? And that's where confusion comes about, especially when people open multiple type of agreements with the same legal entity. So I think while people should be doing their homework, not necessarily everyone does, where it's a little confusing. And I think Catherine pointed out, when you get documentation for a futures agreement, the number of pages of bold and black-lined disclosures can be quite lengthy, and not everyone has the ability to read all gazillion pages.
Yeah, but if you were buying a note issued by the joint FCM BD, you would get, one kind of disclosure, a pretty fulsome set of disclosure. We have customers relying on the FCM BD, and the information they're currently getting about the entity can be pretty sketchy. And I guess the question, I'm not suggesting you equalize them, but based on what we heard from the industry today in terms of covering certain risks with notices and reports and so on, given the fact that it's happening on both sides of the business or maybe elsewhere in the business, it's trying to think through how to get that together.
I understand your point. I don't want to be accused of defending the dealers here. However, I think that the thing to be careful about, there's certain things that unless you go through a future statement, you would not be aware of. So while the disclaimer will say we may do the following things, and it can be a long list of things, and unless you actually go through your future statement and you do it every day, you don't know if they're doing it. And there's something in between, I think, that is important in terms of notification or ability to find out that isn't necessarily easy. And I can tell you we've gone through some statements and we found things that have led us to ask questions. It's just not easy to do.
I mean, I want to press on that, and maybe the members of the panel can help out, because on the one, I think you're right. One is searching for a middle ground between too little information and so much information that people will throw their hands up in the air and not go through the 100 pages. So what should we as regulators be doing? How do we find that balance, or should we be the ones finding that balance? What should we be doing?
Well, I think in terms of if you open a futures agreement, you should be responsible for reading it. It's a one-time event. You can't necessarily take that away, right? It's like, not to bring up another touchy subject, but if you get a mortgage, you got to read the agreement. However, I think that when the agreement says that a firm can do X, Y, or Z, or 1 through 100 items at its discretion, you need to know, okay, which ones are they doing from this menu of items, or if they start to do something they hadn't been doing, I need to know. And having to go through a 100-page document, a statement every day to go, hey, wait, they doing this, not that anymore, right? That is where it becomes difficult, and it's in a place where it's not easy to find. So unless you have technology that goes and looks for it, you're going to miss it. So something there where they do change what they're doing, even though they told you they may, I think is the helpful thing. You can't make it so simple for people. I mean, the reason we have such long documents is because we want to disclose everything. It's just sort of the menu things, when they change them, you need something going, hey, we changed that. It's sort of like when you get a credit card, right? When they change information about what they're doing, they have to send you a notice. Now, most people probably don't read it. However, you do get it, and it's not something you have to go find on your statement.
Thank you. Go ahead, Dan.
Yeah, Dan Driscoll from NFA. One technique you can use to help here is that you can require disclosure that you believe, in your estimation, would be useful for all customers, regardless of their sophistication, and then have other information that a firm is required to provide on request, where other customers that are going to take the time to ask those questions could get it, but not every customer has to get every piece of all that potential information.
Steve?
Yeah, I was kind of going to lead to what Dan just mentioned, in that when you look at the relationship between clients, FCMs, broker-dealers, it's not a one-size-fits-all. The relationships from client to client are different with their FCMs and the broker-dealers. The relationship between the FCM and the broker-dealer is different. And therefore, when you try and do disclosure, if you're going to do disclosure to everybody, it's going to be at a very high level. And I think you have to at least maintain a certain minimum requirement that you have to disclose. And then the question just becomes is what's the relationship between the client and their supplier of services? And it's really for the two of them to go through proper due diligence.
I think what customers might find very useful would be a side-by-side comparison which would examine the differences in the bankruptcy regimes and the customer protection regimes in particular. Things like differences in ability to rehypothecate, differences in the frequency of the computation, differences in the investments that can be done with customer funds. I mean, there's some basic differences between the two regimes, and just a straightforward, simple side-by-side comparison, I think, would be very useful.
Thank you. Carl?
I just echo a little bit what some others were saying, but to Bob's question about what should you as regulators be doing, I mean, there are a couple of different approaches. You could come up with a 50-page document, every eventuality, but as Grace pointed out earlier, nobody would understand it. So I would urge you as regulators to take what I think is the most reasonable approach, and that would be to identify the issues that are common to the greatest number of customers, and then to require disclosure or to make disclosure, as Tom said, at least to the basics or at a high level. Ultimately, that's about all you can really do, and I think that's the best benefit for customers. So if you give them the basics so that they understand some of the basics on both the security side and on the future side, if they're have an account with a multiply registered broker-dealer or FCM, that probably does the most to make them aware the information's there. And then if they want to follow up and get specifics, now at least they're armed with some basic information. And that's the approach that I would advocate.
Katie?
Yeah,
I think we'll give Katie the last word because we're going to, we're done.
Okay.
So it better be good.
I better make it a good
Yeah.
one. No. I mean, I agree with everything that's been said. Further to John's point, with at least some high-level sort of comparison or overview of the different bankruptcy regimes and what could happen, to me, sort of part and parcel in terms of what a customer wants to know does relate to what I think of as sort of clearinghouse disclosures. What also does it mean from a clearinghouse perspective, and what does the clearinghouse guarantee mean? What can I really expect? Because again, I come back to a point I made before. I think there was some misunderstanding based on perhaps the rhetoric that we've used traditionally in the futures industry that led many to believe that a clearinghouse was standing behind the obligations owed to the customers of a defaulting FCM, which is a very basic misunderstanding. It is a misunderstanding that is incorrect. And I recall, post, I'm dating myself, but the Barings default back in the 90s, one of the outcomes of the FIA task force was to recommend sort of a basic high-level clearing disclosure document. But it does seem to me that the issues cross over and are related to the bankruptcy.
Okay. All right. Well, I thank you all for participating, and we're going to conclude the session, and we'll be back in 15 minutes to start our last session of the day on SROs and SRO oversight. Thank you very much. Thank you. Regulate the futures market. Under the SRO system, the exchange, which is the self-regulatory organization, is the first line of supervision of its FCM members. We'll talk about this in more detail in a few minutes, but in broad strokes, the SRO examines its members and the CFTC oversees the SRO. Third, because members could become participants in multiple exchanges, it was clear that if each exchange examined each of its members, duplicative examinations with varying scopes would occur, resulting in inconsistent findings, inefficient costs, uses of resources, and so on. So there's traditionally been productive cooperation among the SROs and the futures markets, including formal coordination of the SRO's compliance examinations of future commission merchants. CFTC Rule 1.52 expressly provides for such cooperation among SROs, recognizing that such a system of assigning each FCM to a designated SRO or a DSRO for exam purposes helps avoid redundant burdens on FCMs, makes more effective use of SRO resources, and fosters important information sharing. And then under Rule 1.52, it reserves for the Commission a role in approving and monitoring the system. Obviously, we want to help look at appropriate modifications that may be needed to strengthen customer protections in the futures and derivatives markets. Now, another piece of background information. When the SRO, and this is all going to be important for the discussion, when the SRO system was emerging, the exchanges were then mutually owned and nonprofit. They were traded on physical floors. There were relatively high costs of high barriers to entry, and it created an environment in which it was widely assumed that the exchanges had significant incentives to self-police and supervise their members because their interests were in protecting their reputation, brands, and products. So it was felt that enlightened self-interest would work in that regard, and that combined with the fact that the exchange was close to the business would help with wiser decision-making. However, by the early 2000s, the futures industry was experiencing a massive change due to new technologies and innovation, as was the rest of the world, of course, but here it created doubts about many of the assumptions underlying the strength of self-regulation. So we went from mutual, nonprofit, physical floors. Computers made the physical floor unnecessary. Competitor exchanges could more easily enter the market. Members became competitors with exchanges, while new exchanges could bypass certain members. Exchanges could issue rules which affected their competitors. And yet those who were in charge of self-regulation might be regulated by or regulating their competitors. It was, as a result of all this, and the exchanges switched from being member cooperatives to public corporations. Conflicts arose that once didn't exist, and the alignment of interest came under scrutiny. So then the industry and the CFTC examined the futures SRO system, seeking changes that would allow self-regulation to work in the new environment. And those solutions were found that were found related to board governance, for instance, by including directors that adequately represented all of the members and independent and public directors. And in particular, the regulatory function of the SRO was placed under the supervision of a ROC, or a regulatory oversight committee, made up of public directors. And the discourse, which began, and Dan and I were just talking about it, the discourse which began in 2003 was finally put in place around April 2009. Okay, so we'll come back to the ROC, but first let's talk about examinations. Let's just start with scope of review. So what does the SRO examine when it looks at an FCM? And is there any need to modernize the scope of that review? And I guess in particular, I don't know if it's fair to talk about, some of the changes that have been recently considered. Ann?
Ann Bagan, CME. So we are required to do a regulatory audit of our clearing member firms every 9 to 18 months, but more typically 9 to 15 months. And they are risk-based, where we look at the history of the firm, whether it's financial issues that they've had or disciplinary issues that they've had, concerns others have brought up with us, as well as a rotational aspect, if you will, of certain programs that we do. The scope of those audits is fully detailed and delineated within those audits, so that we know exactly what we're looking at and why we're looking at it, and that can be expanded as issues are found during the audit. So what do we look at? We spend a lot of time on customer seg, obviously, all the different balances that go into customer seg. That's a huge, huge piece of work for us, and that's tying out to third-party documents, examining, reconciling items to make sure that they make sense and that they're cleaned up on a timely basis. We are looking at capital compliance to make sure our firms are maintaining the minimums at least, and that they are reporting those things correctly to us. Another big area is to look at the firm's margin procedures and make sure that they are following our rules for calling for margin and taking appropriate capital charges when they need to. We look at books and records, we look at AML, we look at sales practice type of things, especially for those that have guaranteed IBs. So the audits, we have 5 months to complete an audit, and for some of our firms, it takes us a good chunk of that 5 months to get that done. If we do not complete those within 5 months, we have to self-report ourselves to the CFTC. So our audits, as life has gone on, have gotten a lot more complicated. The issues are a lot more complicated, and the firms themselves with mergers, and new business practices, they've become more complicated as well.
What are the size of the teams that go out in these 5 months of audit?
Depending on the size of the firm, the teams can be, we've got a couple very small firms that maybe have 2 or 3 auditors. We have very large firms that can take, I'd say, up to 6 people usually. And that's a range of experience levels with an in-charge that takes the lead out in the field, and then a manager back in the office that is there to review everything to make sure it's proper.
Thank you. So, Grace, can I ask you, like, how does that compare with the scope of review which FINRA does for its BDs?
Well, the areas that Ann mentioned, so financial responsibility, which would include compliance with 15C33, the SEC's customer protection rule, and the net capital rule, books and records, margin, those are all very, very similar. Our focus is on the security side. So we don't look at the futures activity unless there's something that's concerning to us. I can't think of an instance recently when we looked at the futures side. We are risk-based, so there's our program is set up so that we have a coordinator assigned to every firm. That coordinator is responsible for day-to-day surveillance and contact with the firm. As we talked in the previous panel about changes to the firm's business, that those changes need to be approved or we need to be notified of them, new products. The coordinator is knowledgeable of the disciplinary history of the firm. The coordinator is also attuned to what's happening in the markets and therefore will be in contact with a firm to assess the impact of what's happening in the markets to the firm's business. The coordinator is then responsible for sitting down with the examination team and actually planning the examination. So identifying which areas, because we have 100 different, that's an estimate, different scope chapters. Obviously, we need to identify a smaller number for each examination. Each year, we identify more thematic priorities that are included to the extent that they're applicable, and we actually send out an examination priorities letter. That letter went out, I think, about 2 or 3, probably 2 weeks ago, January 31st, I think it went out. And the things from the financial and operational program that were included in that letter this year, for example, are price verification. So looking at the authority of independent valuation groups, the communication with the finance group, looking at off-balance sheet exposures, understanding the risks and the margining practices, liquidity, fully paid lending programs, compliance with the new SEC rule 15C35 on direct market access. Those are just examples of areas that are a priority for us this year. So the coordinator, having an understanding of the firm's business, will instruct the examiners as to which of these, what I'll call hot topics for the year, should be included in the current year's examination.
How long does it take to do an average? I'm sure you got all kinds of size BDs, but typically, what would you, in terms of team size and audit team size and time to do an audit?
Yeah, depending upon the size of the firm and whether or not it's a collaborative exam with our sales practice group. So my team goes into almost every carrying and clearing firm, every firm that holds customer assets on an annual basis with rare exceptions. Our general policy is to do an annual examination. If the firm is subject to the alternative net capital rule, which is the rule that allows them to use internal models to compute capital, I have a separate team of examiners with expertise in that area. Those teams, between the FinUp and the ANC examiners, could be probably 12 to 13 people, and then there could be another half dozen people from the sales practice side. We probably spend about 4,000 hours on between FinUp and the alternative net capital side at one of the large firms. And then we have smaller carrying and clearing firms where we can do an exam in 300 hours, the FinUp portion of the exam.
Thank you. Sure.
And as I recall, in addition to your regulatory audits, you also have a group that does risk reviews?
We do. We have a risk management group that is within our clearinghouse that goes out and does meet with our firms on a scheduled basis, and they talk about credit issues, stress testing, liquidity issues, sovereign debt problems or whatever, and then there's a report that comes out that is shared internally on that.
All right, thanks. Kevin, did you have something? Or? Oh, okay. Dan, how about, NFA's approach?
So really, with regard to the annual examinations, we have all of the same areas of coverage as the CME does. Our now, we also do exams of RFEDs and CPOs and CTAs and a lot more IBs, but on the FCM side, the firms we're responsible for tend to be smaller because they tend not to be, well, they're not members of CME, so they tend to be smaller. So we might have slightly smaller audit team size, and the audits might not take as long. And with some of those firms, we probably spend a lot more time on sales practice than we have to on capital. But in terms of the programs and how we approach it, we're very consistent with how the CME handles.
Okay, thank you. Now and Kevin, I may need you to help here. What do we look at when we examine an SRO? And then I don't ask you what you guys look at when you look at an SRO. But Kevin, what do we look at?
Yeah, sure. From the CFTC perspective, we have a group that's focused on examining the SROs, the CME, the NFA, and right now I think we're developing a little bit more into what we're doing, but I think traditionally it's been focused on reviewing the work performed by the SROs actually going into the field, selecting a firm and reperforming the audit work. And I think that has historically been our approach. I think we're morphing that now into getting more into the governance and the how the process is done, and not necessarily going in and reperforming as much, because I'm not sure there's as much value in just reperforming the audit work. Rather, look at the primary objectives, and are those objectives being made, starting at the top of the house and the risk committee of the board, and what are they looking at, and how are issues resolved? Are they being communicated effectively and appropriately? Independence, all of that, good stuff that you would expect would be happening at that level, and then taking that down to how are issues raised up to that level. What's, if there's a business conduct committee, what happens at that committee? How do things get raised? When issues are identified at a firm, how are they resolved? Are they, appropriately reviewed by the supervisor in the field and waived and said, yep, I get it and that's okay? Or are they raised up the line? Are the right people involved in the decision making? So taking, I think, a slightly different approach, and we will look at work papers, because we still have to say, did the SRO, was the exam properly supervised? Were the people properly trained? Were they properly qualified? Did they follow general accepted auditing standards? Were conclusions and work papers properly documenting what they found? Did they draw the appropriate conclusion? Were issues identified at the report level, and things like that? But I think that's sort of a high level of where we are, where I think we're going, and I think we'll continue to evolve on that process. I think we need to look a little bit more at sort of the environment, and not necessarily just reperforming the work, which is where traditionally I think we have been, which was effective, but now it's time to just think a little bit differently.
banks. So Tom and Grace, but I don't know how different your SRO system is from ours. So and what you examine versus whether you have something like we have. So how does your SRO system work?
Great. Well, maybe I'll give a little overview and then address some of the examination issues at the end. And I'm less familiar with the SRO process on the future side, so maybe things are, I think there's more similarities and differences. Okay. But just kind of go through the basics. I mean, every broker-dealer registered with the commission before can do business as a broker-dealer needs to be a member of at least one SRO. If you're a member of more than one SRO, for example, if you do work on one exchange or another, and more than one exchange, you could be members of two SROs. One's going to be designated as the designated examining authority for the broker-dealer. That SRO will have primary responsibility for enforcing the financial responsibility rules over that firm. So responsibilities, the intent is responsibilities to be allocated in an efficient way, clear and efficient way among the different SROs. Also, if a broker-dealer is going to do business with the public, it has to be a member of FINRA. So FINRA, is the DEA for a great number of firms, but sometimes firms are members of FINRA and DEA to another SRO, depending upon where the majority of their business is. The SROs, similar, I think, to the CFTC's approach, the SROs on the security side are the frontline regulator of the broker-dealer. They're responsible for the day-to-day monitoring or monitoring between examinations of the firm. They have the primary examination responsibility for the broker-dealer. The commission can do exams as well, but the SROs are thought to do the first-line examinations of the firms. SROs on the security side also have a number of rule-writing responsibilities. They've been allocated, especially for suitability purposes, but there's been a range of rules that have implemented that deal with customer relationships and business conduct, withdrawals of capital and things like that, where the SROs have their own rules that have to be followed by the broker-dealer as well. And also, a lot of the financial reporting is done through systems set up by the SROs. For example, the monthly focus reports that are filed by broker-dealers are, for the security side, are submitted through the SRO and then made available to the other regulators. So that's another responsibility that they do. But just like broker-dealers, SROs also have to register with the commission, and they're subject to commission oversight. They're subject to examination, reporting requirements with the commission. One of the biggest responsibilities the commission has for an SRO is review and approval of their rules. So any time that a change is made to an SRO rule, it has to be filed with the commission. Notice, if it's significant, would have to be noticed for comment and ultimately approved by the commission itself. So there's a commission role in approving most of the substantive and even operational rules at their SROs as well. As similar to the CFTC, the SEC does do examinations of the SROs themselves. And I think we'll cover a lot of similar topics that you've described, Kevin, about how they follow their internal procedures and whether they're the ones that have been drafted and reviewed and approved by the commission are actually been implemented. There's also a review of how the SROs do their financial responsibility examinations that I'm a little more familiarity with. So our examiners will go in, and it'll be a team, from a half dozen or more, depending upon, the availability of staff and the breadth of the examination, to review examinations that have been done by the SRO, look at the work papers, look at the broker-dealer materials, to see if when the SRO is following its own procedures there again, and what they look at, whether they've done an appropriate job of assessing what areas need examination, that issues have been escalated appropriately, and also to see whether they've interpreted the SEC rules correctly, so that sometimes issues come up where maybe the rule's not as well understood as it should be. So this is an opportunity to correct those as well. The other thing I'd say that's kind of in a more macro level is that on the SRO side, on the securities markets, a few years ago, there was a separation between a number of the SROs and the market they were with, most notably the New York Stock Exchange.
and the NESD split off their SRO function to to FINRA. Ultimately, New York Stock Exchange regulation responsibilities went to FINRA as well. So that's another thing that's a little bit different on the securities markets, I think. So.
Thank you.
Just following up on that, Tom, we know in many ways, the CFTC and the SEC, I assume the same, part of our function is to provide an oversight. And, when I first got to the commission, I was thinking about it and saying, well, the accounting firms, I'm pretty familiar with their approach, they have the peer reviews, they have the PCAOB review of their firm. Do you view the SEC in a similar way, or where the peer review of an accounting firm, it's looking at how well the auditors didn't audit?
Well, that's a good question. I wouldn't say necessarily, without being, I'm an attorney versus an accountant, so familiarity with the exact procedures, you'll forgive me for that. For the exact procedures of a peer review, I think the intent is not too different to say that what could be done better in the process of their oversight. Because we do examinations as well, broker dealers, so I think there's some ability to learn from that and inform our reviews of the CFTC. But it goes, like I said, it does go to, are the examinations effective? And so I think, which is real hard of the peer review, not just that they're following the procedures and interpreting the rule, but are they effective for what they're designed? That's a harder thing to look at, but it's I think it is one of the goals.
Thank you. Hey, Dan, how will, and Ann, I guess, how will, and do we know at this point, how the system will apply to swap dealers and MSPs? I mean, they will be members, but they might also be joint. They could be an FCM that ends up, registered as a swap dealer. How do you think it's going to work?
Right. Dan Driscoll, NFA. So we don't know at this point. We know most of the firms that are going to come in with at least one swap dealer, but we don't know which of their entities they're going to register. But I think it's probably safe to say that there'll be at least some firms that are both registered FCMs, members of the CME, and registered swap dealers, members of NFA there. And we haven't really discussed this yet, but given our history, I think the inclination would be that CME and NFA would get together and figure out a way to do those examinations where we both fulfill our mandates to the commission and to the public and not duplicate efforts. And so that, for instance, swap dealers have both internal and external business conduct rules. My guess is that NFA would do examinations of those. The CME's probably not going to have rules on their books that require these firms to comply with those. The CME is already doing basically the capital exam and looking at seg funds. So either going in at the same time or at different times, I think the best bet is that we'll work out a plan where we cover the waterfront and don't duplicate.
Ann Bagan, I totally agree with you. We will do reviews if those entities are clearing members or members of CME. But Dan's right, we're going to have to do coordination between our two firms.
And would you view that as a joint audit? I know there's pros and cons of that, biggest con being trying to coordinate it.
If we go in together?
Yeah, going in together.
But I think Dan is right on how we would split up responsibilities as well.
And I know from the feedback have gotten from members over the years that they tend to, most of them prefer joint audits as long as we don't completely overwhelm them for a long period of time. They prefer that to two separate exams. So we may very well do quite a few joint audits. And we do that with, over the years, we've done that with FINRA as well.
So now I want to jump to a question that goes back to the reason I laid out this history thing before, because of the SROs putting their regulatory function under the oversight of a ROC, over the Regulatory Oversight Committee. And I just, you know, in thinking in terms of the incentives that may affect the quality of supervision, you know, examination and the regulatory function generally. So is there, from the, I guess, the non-SROs, is there, how's the ROC system doing? Is it work the way it's supposed to? Is there a need to make any adjustments? Is there any reaction to that at all?
Carl Gilmore, Penson. Well, first let me say that we have, as a regulatee, if you will, I look around and I think that I have been through an audit over the years by each and every one of you at some point.
Maybe tomorrow, too.
Yeah, you're right. Maybe tomorrow after that. But with respect to Penson, certainly on the future side, our designated examining authority has always been CME. And as you know, from time to time over the years, there have been some debates since they went public whether or not they ought to have regulatory authority over their members. And I will say that it has been my experience that I think the staff has done a great job of managing that potential conflict. And so ultimately, what I really think that we should be thinking about and what we should be talking about is with respect to the SRO system. And by the way, I didn't know it went back to 1859. And so if you look back over that 130 years, other than the some recent events, that system has worked very well. So I'm not of the view that the SRO system itself is broken, but it is the 21st century, and we ought to, just like we do with other areas of our business, particularly in our risk management, it's always looking at ways to improve it. It's always looking at ways to do things better, and it's changing as the environment and the conditions change. So having said that, it's always been my view that I think that the ROC system has worked well, but I think there is some utility to the industry and to customer protection to continue to discuss and continue to monitor that and continue to see how it's working.
Yeah, I would agree with Carl. I don't think the SRO system is broken or inherently flawed. I think there's some things that could be done perhaps to improve it, I suppose. I mean, one is a coordination of exams. A couple of folks talked about this. For joint broker-dealer FCMs, I mean, obviously we're subject to audits by CFTC, SEC, the SROs, DSROs. For entities that are banks or affiliated with banks, we're subject to audits by the Fed. State auditors on the security side on occasion, various exchanges and clearing corps. So it's a full-time job really just to manage all these audits, and it does take a lot of time and a lot of resources, and you know, internal staff time. So you know, the ability to coordinate these, I think, would be appreciated on the firm side, and I think it probably could be useful to the regulators as well. I mean, you know, having a securities team and a futures team go in and look at the same BD FCM at the same time, there's going to be a lot of information sharing. There's going to be knowledge sharing, cross-training, and you know, less situations where the same issue will be looked at by both sets of regulators. I mean, there are situations where, you know, one of the teams will come in and take a look at something that doesn't necessarily relate to futures or securities, but may relate to overall supervision. You know, how does this firm handle personal trading? How does this firm review outside business activities? And then, you know, that might be the securities regulators, and then 3 months later, the futures regulators look at the exact same issue. That type of overlap might be avoided. But again, I agree with Carl. I don't think it's a flawed system. I think maybe just a few tweaks here and there.
Thank you.
Hi, Bill DeLeon. I would tend to agree that it's not a flawed system. I do think, though, that the frequency and the type of audits needs to be reviewed and updated. From my standpoint, we're very concerned both in terms of the fact that the audits are done 18, 15, 12-month intervals, and while for a business or a financial entity that makes sense, given the size and scope of what's going on, doing a deep dive into all the processes is certainly a good thing. I think, though, that if you look at what we're trying to rate, what we're worried about on the buy side, or what I'm worried about as a steward of our clients' capital, that's not frequent enough. So if you think about the extreme other end of this, when we open a futures clearing account or a derivatives clearing account, we get audited by the exchange we're doing business with via our clearing agent on a daily basis, right? We get a margin call on a daily basis. We have variation margin we have to post. We have initial margin we have to post. If the haircuts change, if the price, this is done in virtual real time. And then there are a few exchanges that are not here that actually do intraday margining. And I know that's been a topic. I'm not going to bring that up. So there is a really extreme here. And then if you look at what happened 4 months ago, while there is an audit process and things in place, what happened evolved relatively quickly in a rather nasty manner. So the question is, how do you prevent that from occurring, because the frequency of audits are not sufficient? I can tell you, if I don't post margin for one of my clients today, tomorrow I'm getting a nasty phone call from somebody going, where's the margin? So given that's the standard for the people we do business with, and John probably knows this as well as anyone here, because he probably is making some of those phone calls or has people working for him who are, I can tell you I don't ever like getting that phone call, and we strive incredibly hard never to get one of those phone calls. So given that's the standard, I would think that we'd want to have similar type of, not deep dive business standards, but in terms of making sure what's in the box is there and checking it and ticking and tying things out, so that if a wire goes out from the wrong account, someone knows the next day that money's missing or not accounted for, because that's a red flag. And I can tell you that at our firm, we are looking at a huge amount of data for all of our wire movements to and from custody banks, to and from dealers, because we want to know today or tomorrow that there was a problem yesterday or today. We don't want to know in a week or in a month or in a year. And if you think about when you do a financial audit, right, financials release quarterly and they make statements on a regular basis. So as a standard, I think you're supposed to be moving there. So it's not that it's broken. I just think that, as a few people said, we're in a different world than the 1900s. And we need to be much more real time, and that will help, given the amount of money that's moving, the amount of volatility in the market, and the uncertainty.
Thank you. Sandy?
I guess from our perspective, I do agree that the DSRO function is working well. I would like to see potentially the time frame shortened on those, because when it takes us 6.5 to 7 months to get the audit report, then I'm down to a shortened amount of time to potentially implement the procedures we need to improve things. And then the other issue I see is, it seems like I get in the middle between the exchanges a lot, and I don't really know what the Joint Audit Committee is supposed to be doing, but if I'm always telling other exchanges, I think you should contact the Joint Audit Committee about this, about these issues.
Example, can you give an example?
ICE constantly is calling me about things, and I'm like, I think you should call the CME about things. Because I'm like, I have reported things to them. You need to call them. Don't call me. Because I thought the whole concept of the DSRO function was I only have to report to one person.
Can you give an example of such a thing?
No.
Fair enough. Well,
But that is one thing I don't like. And I don't understand
so why don't we,
that.
yeah, so offline, maybe we could talk through some live
Yes.
examples so we know what you're saying, so we
Yes,
understand. Okay,
yes, and
fair
I-
enough.
yeah.
Fair enough. Okay, so, go ahead, Carl.
Sorry, Carl Gilmore from Penson again. One thing, I just want to address a couple of comments. One thing I think that has been a benefit over the last few years, and I would urge regulators, both self-regulators and government agencies, to continue to refine, is the concept of risk-based auditing. I think that concentrating and determining and refining risk-based auditing, it has a number of benefits. First, you get to deploy your resources, which are scarce, on a more efficient way. Second, in our own self-interest, as a regulatee, we end up dealing with things that matter and not things that don't matter. And so what I would urge you to continue to think about how you can refine your risk-based auditing programs. And then just a second comment, going back to what Bill said, one of the benefits, I think, of the SRO system is the flexibility to not have to wait a year or 18 months. That might be the schedule, it might be the framework, but again, going back to risk-based auditing, if there's a risk, and certainly within the last few months, we have seen teams come and audit off of that schedule. I think the SRO model allows great flexibility for coming in on a more on a closer basis, on a more uniform basis, and more times in a given time period if they think there's a risk. And that really comes down to defining that risk-based model. So I think you're probably right that a year or 18 months is too long if there's no other exchange of information in that period of time. But I think that now in the 21st century again, we've gotten to the point where we're communicating on a very regular basis with the SROs and with the agencies. And so I would be highly surprised that if something happened because there had been no communication with any registrant for a period of time, months, let alone a year.
Grace.
Yeah, it's Grace Vogel. If I left the impression that we will only go in on a one-year cycle, that was the wrong impression, because if we identify a problem or a concern, we will go in immediately at the time that concern is identified. One thing that we have also been doing is using automation more efficiently to conduct our examinations. So we have, I think it's approximately 60 firms now who 1 month before we start our exam, they actually provide us with their stock record, their customer reserve formula allocation, other records in an electronic format. And we have various programs that we run against that data to select our samples for testing and to conduct reviews in the office before we actually go out on an exam. That helps us better identify problems because we have a sample that's more knowledgeable, and it allows us to refine the work that we do in the field.
Thank you. Thank you. Sure.
Just want to follow up on a couple of those comments because, risk-based auditing, to us auditors, that's a sexy thing. We all love that. But what are you thinking specifically? Are you thinking more targeted reviews? Are you thinking more control-based? Are you thinking, let's go in, spend some time with management, try to get a feel for what is the risk in the firm, and just focus on that? What's your thoughts on that, Carl?
Carl Gilmore, Penson. I think it's all of the above. And it really depends on a number of factors. It depends on the kind of business. It depends on what's happening in the marketplace. It depends on the financial condition. So I hate to just say it depends, but it really does. But those are the broad categories, and depending on who you're auditing, when you're auditing, what's happening out there in the world, and what's happening with that business, it could be any one of those.
I wanted to put a specific question to you all. So we note that swap dealers, MSPs, FCMs are now all required, as implementation occurs, will now all required to have CCOs which operate under certain duties and provide certain reports. So here's the question. Is there any reason why similar requirements should not be imposed on the Chief Regulatory Officer of the ROC? The idea being, would that strengthen the ROC? And so that's the question. We know that the ROC typically has a CRO. Should the Chief Regulatory Officer have comparable duties relating to the ROC, not reporting to the general company? Ann, do you have a thought on that?
We actually call ours MROC, Market Regulatory Oversight Committee, and both the people that run our trade practices and compliance area within market regulation, and then also me for doing financial surveillance. We do have a dotted line reporting line to the independent board members that are on that committee. And we meet quarterly and we report out our results, the investigations that have taken place, the audit findings, what kind of penalties have been given out. And in addition, they review our compensation and our performance evaluations. So we've had this for a number of years. I think we had it long before it was actually a requirement. And it seems to be working well. There's an open line of communication if there are issues. They're very, very focused on whether we're able to make our regulatory decisions in an independent fashion. So it appears to be working very well for us.
Okay, thank you. Any other thoughts? Carl?
I'll give you the market participant view. I think it really comes down to what the standard is as a practical matter. So if you want the Chief Regulatory Officer to certify to everything with all of the members that they audit, that's probably not realistic. But if you have a sort of a reasonableness standard, there might be some benefit there in terms of offsetting any potential conflicts. That might be one way to deal with that. But I think it's really got to come down to the standard as to what you'll be holding that Chief Regulatory Officer to.
Okay, thank you. Other thoughts? Nope. Okay. General question for you all. What other issues should we be considering with respect to the SRO oversight function? Very open-ended.
I'm sorry, I missed the question. What was that?
What other issues should the Commission be considering with respect to our oversight of the SRO?
It's Ann Bagan. Well, to be honest with you, you're in on a quarterly basis, so I'm not sure what more you can be looking at with us. But again, we do have a very open line of communication. One thing I can say is, and maybe this is a little bit to Sandy's point, but we'd like to get the results of those reviews on a more timely basis, so we know what we need to be thinking about or working on.
Okay. Other thoughts? Dan?
Well, obviously, NFA and me personally are big advocates of self-regulation, but I also believe the self-regulation really can only work if you have strong and effective government oversight. And so, while we too might get frustrated every once in a while with all the visits from Commission staff, but it's something I think we really treasure the relationship and the frequent exchange of information, and I think it works quite well. So I don't have a specific recommendation for other things that you might do, but I can assure you that if something crossed our minds, you'd be the
Sign
first
it
to know.
over, yep, yep, okay, okay. Do you have anything you want to? Kevin, do you have other points? Tom? Okay, all right, so I think we've run through our questions. Your participation's been very helpful, the input, we greatly appreciate it. So we're going to call it in right now. Thank you all very much.